may be permitted to mention item 82 of your lordship's list. So this is an order challenging an order passed by the Honorable TR80. Lordship, peculiar situation. I am neither the borrower nor the guarantor.
What do you want?
Lordship, upgradation.
Item number
82 of your lordship's daily list.
82.
82.
Why did you not mention on Wednesday? Yes, call the list.
Lordship, any day convenient to your lordship. Lordship, I am unable to sell my flats.
May I have your lordship's leave to pray for a leave, my lord, to file without the certified copy, my lord.
What is the urgency?
Urgency is, my lord, an order application has been filed under order 21 rule 9900, and my application has been dismissed. My lord, the execution proceeding, the next date is fixed on 2nd of August, my lord.
When the order was passed?
Order was passed on the 10th of July. However, it was uploaded on 25th of July. We came to notice on 25th of July. We have applied on 28th.
File with the certificate.
Grateful.
It has been pointed out that যে নোট করেছে তাকে ডেকে পাঠান। it has been pointed out that in the orders dated first
Number three,
Lord, here, Lord, well, one of the mistake you said that our mistake, Lord, that Pradeep has been in the name of the opposite party, it will be Probir. Your Lordship kindly grant us leave to correct it from the cost title. And Lord, in the second page, this court's mistake.
second page,
Lord, third paragraph, kindly see. Your Lordship directed the interim order till September, but the matter has been directed to appear 12 weeks. Last sentence.
এটা কোনটা দিলেন ফাইল? আবার অঞ্জনা বোস 1 নম্বরের ফাইল দিলেন তো। Contested application after 12 weeks.
But Lord, third paragraph, September, interim order.
Oh, September.
It will expire, Lord, much earlier.
Then I'm changing the returnable date of contested application because
Then that will do. But Lord, in say Puja vacation will intervene. That's why your Lordship fix it. Puja vacation will intervene. That's why, Lord.
if it is 8 weeks, puja vacation will not commence. It has been
The opposite party, my lord.
opposite party petitioner. Passover next.
Item number 8.
But I appear for the opposite party.
Who is for the petitioner?
I'm for the opposite party number 1.
But I appear for the opposite party number 3.
But who is for the petitioner?
But
Passover next.
no copy of the extension application has been served.
You have taken, Mr. Bose, you have taken a resolution today.
Yes.
I have not. The bar
You do not form part of the bar association.
not part, but I'm not. The bar association have taken. And I
You have taken a resolution saying,
being the member of the bar, I have to accept the
what is the resolution?
not to pass any order in the absence of either of the parties.
Passover next.
Item number 9.
I'm for the principle of interim, and no one is there yet. You'll have to carry-
Cannot be. Mr. Ghosh today it cannot. Passover next.
Item number 10.
Passover next.
Item number 11.
Lordship, I'm for the petitioner. My other side was here right now.
He has vanished.
She,
Then what can be done? Who is appealing?
Miss Kumkum. Yes, because they are appearing today for the first time. Yesterday only they informed us that she will be appearing for the opposite party.
Passover.
Who was here?
Passover next.
Item number 12.
I'm for the petitioner, Lordship.
Have you served? Where
Affidavit
is
of
the-
service.
Passover next. Come. It's a document. What is your item number?
7.
Item number 11.
Lordship, my interim order will expire today. Mahalakshmi.
I'm for the respondent.
I'm for the tenant, Lordship. 7-2 directed me to pay, Lordship, 1,16,000 and odd. But we challenged, Lordship, the landlord-tenant relationship. That was not decided by the impugned order.
The tentative finding will be decided.
Lordship, kindly see how the learned judge has decided that. Lordship will kindly come to the 3rd page of the order impugned.
Madam, are you ready with the main matter?
Oh, my lord.
All right, I am extending then. Heard the learned advocate for the respective parties. First up, the interim order is extended till the end of the month of December 2025 or until further orders, whichever is earlier. It is appearing as contested application in the list.
It appears. Yes, yes, yes.
Let the matter retain its position in the
And
list.
my lord, the direction may be given to file affidavits, my lord.
What affidavit,
My
madam?
lord, the
Civil division application, no affidavits. What affidavit? You cannot improve upon the case that what has been made in the learned trial judge.
Great, your Lordship.
If any document has not been annexed, you can
my lord.
bring those documents. That can be accepted.
Item number 13.
Yes.
13, I appear for the petitioner, my lord.
My lords, I appear for the opposite party number 1, my lords.
This is for extension of the interim order granted by your lordship on 30th April 2025, my lord. It is expiring today, my lord.
My lords may kindly consider this is a matter, my lords, where they filed already a 7-1 application has been decided against the original tenant. And my lords, after being substituted, they file a fresh application. My lord, the statute bars it. And my lord, that would have been filed after the period prescribed. My lord, no section 5 also lies. My lords will see in the application they have preferred a 7172 application with a section 5. So admittedly, my lords, it is not maintainable also.
Now the issue is pending before the Supreme Court with regard to this section 5. Ashun, the matter is appearing in the list.
No, my lord, it is not.
It's not appearing. Heard the learned advocates for the parties. The interim order, the subsisting interim order is extended till the end of the month of December 2025 or until further orders, whichever is earlier. List the matter under the heading contested application after 12 weeks.
My lord, may I make a request, my lord? One request. My
Yes,
lord, if the proceedings before the learned court below can continue, my lord, subject to outcome of this petition. My lord, otherwise, my lord, I am at the evidence stage.
because the question of striking out the defense will be
My
there.
lord, we are not taking that defense. My lord, may record that.
You may not take, but the statute, it's automatic, sir.
My lords, on that aspect, may leave it aside, my lords. At least let the evidence proceed, my lords.
Yes, call the next matter. Yes.
My lord, I'm appearing on VC. My lord, 14 and 15 are connected at tag together. My lord, I am appearing for the petitioner in 14 and for the opposite party in 15. My lord, in 14.
Party, who is appearing? You are appearing. The opposite party is not here, madam. There is a resolution also. Passover.
My lord, may this be kept tomorrow then, because today the interim order is the extension interim order is expiring.
Will appear tomorrow. Yes, Passover next.
Grateful, my lord.
Lordship.
Item number 16.
May I please, your lordship, my lord, I'm for the petitioner, for lordship. Today is the last day, my lord.
Cannot be. The other side is not here. Passover next.
Interim order, your lordship, extended till today, 31st of August.
Move that, but what can be done? Other side is not here, and you have taken a resolution. Yes.
Come tomorrow.
Passover next.
Item number 17.
Then. None appears for the petitioner. Yes.
Item number 18.
18, my lord, I appear for the petitioner, my lord. There is
Yes.
no caveat.
No
There
caveat.
is no caveat. But this is an order by which a section 34 application has been permitted to be amended by putting in additional grounds.
Yes.
My lord, I would humbly submit, subject to my lord's interpretation, that this law is settled, my lord, with by a coordinate bench judgment of this honorable court, where, my lord, the honorable court's finding was to the effect that if the grounds which are already there in the section 34 already filed, if the new grounds proposed to be added are not related to that and are different grounds, it's really like filing a fresh section 34, which cannot be done after 120 days. That is the maximum statutory limit to file a section 34. So, my lord, what they have done is, after, my lord, 3 years, 4 years, the petitioner, as in the section 34 applicant, who is the opposite party herein, has filed an application after the commencement of the arguments, after filing of the notes of arguments. They have filed an application under, my lord, Order 6, Rule 17, praying for amendment of that of the application by putting in additional grounds. That, my lord, has been allowed, from which I have come up before your lordship in the revision.
Officer of the coordinate bench.
Yes. Mr. Ganguly, please handle. Yes, my lord. Your lordship could kindly see. Well, this is Justice Bhattacharya's, my lord, judgment. Kindly, my lord, takes a look at the first paragraph. This shows the facts that amendment application was moved for additional grounds. No, Mr. Ganguly, Justice Prakash Industries, that judgment.
Prakash Industries. I have given that.
Yes.
Para 11.
Now, my lord, will kindly have a look at paragraph 11 onwards. That, my lord, the test whether an amendment is permissible or not, as held in a decision cited by the council, is whether the proposed amendments would warrant a fresh application. My lord, here, if your lordship kindly sees the schedule of amendments, and then I'll take your lordship to my lord, the section 34 application. I'm led by Mr. Banerjee, my lord. I see he has already come, my lord.
Yes, Mr. Banerjee.
My lord, whether the same principles apply or not, and if so, what is the rigor of those principles? Recent judgment of our honorable court, my lord, after considering the entire issue of amendment of a section 34 application.
This is Prakash Industries.
her ladyship was of the view, and this has not been appealed from, I have checked up. So her coordinate bench is of the view that principles of Order 6 Rule 17 and principles of 120-day barrier both will have its application in the facts and circumstances of the case. 120-day barrier is this: beyond 90 days, you don't have a right to challenge the award. Up to 120 days, the court can grant another 30-day leeway to a belated applicant to challenge the award. But that 30 days is not a matter of right. So if that 120th day expires on a holiday, you don't get the benefit of the Limitation Act.
If 90th
day expired on a holiday, then only you get the benefit.
you can file it on 91st day, not on,
day, not a problem. But
not on 121st.
121st day, it's time barred. And here it's a limited power of condonation. Beyond that, time barred. Taking all that into account, what has been two principles that have been stated.
Show me the grounds in the amendment. What are the additional grounds?
Yes.
Show me the original grounds and the additional grounds which they want to see.
Copy below, section 34, copy. Anani? I show you, Lordship, Lord D.
So, Mr. Banerjee, this principle will apply also in amendment of grounds in a memorandum of appeal also.
Yes.
Any other appeals.
Yes. They also,
because any appeal has a period of limitation and condonation is not a matter of right.
Right. So the moment you go beyond that time, the question comes of you're actually putting in another appeal. In de facto, you are putting in another memo. Here, de facto, you are putting in another section 34. I could have understood small corrections which are of the nature of, let us say, errors in typing, etc., which can always be done away. That the court has the power itself to see.
Arbitration and Conciliation Act.
Yes. Now, we have a Supreme Court judgment which says that even in case of 34 and 37, which is an appeal from section 34, there also the principles which are applicable are more or less akin to the 120-day limitation bar and introduction of new grounds which have no nexus with the earlier grounds. It may have nexus with the facts, but if the new grounds are suddenly sprout out without having any nexus with the earlier grounds as such, then they should not be allowed by way of amendment. That is the other side, that's it. No. If your lordship is so pleased, my lord, can hear us on this issue. This is something which my lord would be pleased to decide.
No, it has been decided, Mr. Ben.
Decided, apply. Then, my lord, in that case, my lord, if your lordship is so pleased, lordship can hear the other side out and finish it off. Prima facie, my lord, there is a case which I have made out. The only thing is that after hearing the other side, subject to my lord admitting the petition, my lord would be considering whether they come within the two ingredients which have been given for turning down amendment.
Show me the where is the original section 34 and where is the
original section 34 difficulties, my lord. I am told that there's some dislocation today because of this. They've been unable to bring, my lord. I told them to carry separate copies instead of annexing it.
Then you bring the original section 34 application. On the prayer of Mr. Banerjee, learned advocate appearing for the learned senior advocate appearing for the petitioner, hearing of the civil division application stands adjourned for the day. Just next.
Yes. Chalo.
Item number 19.
And the petitioner.
Yes.
Expedite disposal of this petition, lordships. The matrimonial suit in 2022, lordships. In connection the matrimonial suit, lordships, wife filed an application for maintenance alimony, lordships. That application is still now is pending, lordships. And see in the last page, lordships, on the ordership, learned trial court passed an order unless the James case is
this application. What is the stage of the James case?
James case, lordships, they file application for amendment. Initially, lordship, both are husband and wife, both are the government employee, lordship.
This application under Article 227 of the Constitution of India is a
Advocate record.
Praying for direction, my lord, for disposal of, my lord, my application under order 1 rule 10 to, my lord, within a time bound manner.
When did you file that?
This has been filed on 14th of May, my lord. This is with regard, my lord, partition suit, my lord. The preliminary decree has been passed. Thereafter, I have, my lord, purchased 90% of the entire shares of the property, my lord.
14th of May, you have filed.
Yes, my lord, I have filed, my lord.
Where is that order sheet?
Well, last order, my lord, very last order. Very last order, my lord. A commission work is going on, my lord.
So 14th of May you have filed.
Yes, my lord.
And it has been fixed on 29th of August.
Commission, my lord, may I only say, my lord, the judge is not
into everything.
My lord, the
This
judge
application also.
may only.
Maybe.
Well, 21 is my matter.
Yes.
Here what happens, the suit for specific performance of the contract, it was filed by the one dependent plaintiff here.
What is the order impugned?
Well, kindly, the order impugned, my lord, the learned advocate contesting the matter on half behalf, that is KMDA, my lord, he expired. The day when the matter was taken up, the junior, he could not hand over the briefs. The matter order was passed. My lord, kindly comes to page, it is volume 2, na?
Volume 2.
Well, there are 2 volumes of this. Kindly comes to page. Volume 2A.
What is the suit for?
Specific performance of contract. Well, KMDA was allowed. KMDA.
Section 5, miscellaneous case is order 9 rule 13.
Yes. And there.
Section 5 dismissed.
Dismissed.
Miscase dismissed.
Miscase dismissed. I
So
filed.
it's an appellable order, sir.
I filed a misappeal against the dismissal of the miscase, and this order, my section 5 application, my lord, for that I have come up before the.
Can it be done, sir?
Well, this was.
So there's a Supreme Court judgment, Honorable judgment.
Well, I am aware of that, man. Now what happens here, my lord? Kindly see.
Revision is not maintainable. That section 5 is a decision in the appeal. Have you gone through the decision in the case of?
I have.
And you have preferred.
Yeah, prefer we prefer an appeal for the miscase, my lord. We have preferred an appeal, my lord. But now what happens?
Sir, what you are saying was our earlier full being judgment of 1976 Calcutta. That has been overruled, sir, in 2005. Ashwin, by the order impugned, the application under section
Item number 22.
My lord, item 22, Mr.
Is not entertained ওটা বলে দিচ্ছি তো সিও না
In this matter, I am appearing on behalf of the
yes
order 7 rule 11 has been rejected.
yes
Against that order, I filed this application. And it
Yes.
will appear from the plaint itself that this suit is hopelessly barred by limitation. I am submitting
show me
the
the
facts.
plaint show me the plaint
Kindly come to page 15.
please give me a minute Mr. Chaudhary.
And he has challenged 5 deeds. And knowledge of this deed, he got the knowledge in 2004 in connection with a suit filed in 2003. Now, after challenging all these 5 deeds, he filed a suit.
After going through the after going through
Item number 24.
24 yes
For the petition, Lord.
yes
Lord, there was a caveat, Lord.
deviate then Mr. Ghosh it's
Lord, one thing, Lord. This matter, Lord, this suit has been dismissed in compliance with the court's order. Lord, because in an application adjournment that a review
that has been dismissed for default
yes.
then how civil division application is
Lord,
maintained
because Lord, for non-compliance with the court's order, we prefer an appeal before this honorable court. The division bench held, then under the definition of degree section 2, subsection 2, there is no, it should be, no appeal is like, no
Where is the
appeal
division
lies.
bench judgment
Lord,
you have annexed
not annexed, Lord,
so in this matter or in other matters
in this matter. Lord, I am reading, no appeal lies against the impugned order, which is a judgment of dismissal of the plaintiff appellant's suit for default. Section 2, subsection 2B.
Mr. Ghosh can you please give me that
Yes, Lord, kindly.
please give me your gadget But Mr. Ghosh dismissed for default. Uh, uh, there is a provision under the Code for Restoration.
Yes, but
And there's a Supreme Court judgment which says that if there is a provision in the Civil Procedure Code, that has to be followed, and 227 is not maintainable.
but here what happened?
2019,
We are directed to show cause. We shown cause.
maybe whatever
That has not been accepted. The same cause would be shown how, but purpose would be shown.
2019 judgment, I think Tuticorin Education Society or something. It has been said 227 is a near absolute total bar. That's the language used by the Honorable
That's
Supreme
why we prefer the appeal, because for non-compliance with the court's order, his lordship has not.
This is a Supreme Court judgment, Mr. Ghosh. That's the Supreme Court judgment. Near total bar, absolute bar or near total bar. 2019, I forget the volume. Tuticorin Education Society. That's the and I've considered that in one of my judgments in civil division application. Mr. Gopal Mukherjee appeared on one side and Mr. Ratnanko Banerjee on the other side.
Lord, what is the reference? Your lordship?
2019, volume exactly I do not recollect. Tuticorin Education Society something.
Tuticorin.
So this was considered, and subsequently also that decision has been reiterated by Justice Bagchi in a recent decision of 2025.
But then Lord, again we'll have to go approach this court. Paid 50,000 rupees court fee in appeal. Thereafter, the appeal court said that it is not maintainable. Therefore, Lord, the revision application was granted leave to take back the certified
Mr.
copy.
Ghosh, please, I am adjourning this matter. Please go through that judgment, because that's a Supreme Court judgment,
Lord, if your
which
lordship,
deals with all the provisions, because Mr. Ghosh, it's well settled that even if there is an alternative efficacious remedy of appeal, 227, 226 is not a bar. Under certain exceptional circumstances, it can be. But the Honorable Supreme Court has distinguished this with regard to the remedies available under the Code of Civil Procedure.
Lord, that Lord, but here Lord,
The Honorable Supreme
what-
Court said, no,
what would
cannot be done. 226, it's a near total bar. That's the language used.
Lord, what ground we shall set there? We shown cause that
Mr. Ghosh,
that
let
has
us
not been
forget
accepted.
about non-compliance. If you do not appear, the plaintiff does not appear, one line order fails to appear, dismissed for default. So what's the adjudication? That's dismissed for default. Unless you restore that, end of the matter, you cannot. So that's the adjudication.
Then-
Rights cannot be further adjudicated.
I think Lord, the court will not restore because he has given reason that I have not complied with. And Lord, in that case, Lord, again we'll have to.
Host, that's the, you have to apply for that. If not, you have a remedy of appeal, but not directly under 227, not directly under, but there you have preferred an appeal. Appeal is not maintainable. You have to apply for recalling of that. Order 9 procedures have to be applied. Appeal rightly said, not maintainable. Because there is a provision for appeal. Sorry, there is a provision of restoration of the suit. Order 9, Rule 9.
Yes,
So without invoking Order 9, Rule 9, because with the appeal, you have to first show cause what happened. Unless that is done, what the appeal court will do?
Lord, we have shown cause. Here kindly see. Show cause, it was fixed for show cause.
I
Showing cause.
appreciate that, but you have to first approach the trial court, show reasons. After that, appeal, yes.
Lord, you-
Directly appeal is, what is the appeal? You have preferred a regular appeal.
First appeal.
It's not
Effective.
maintainable, rightly held. And the 227 is not maintainable in view of the Supreme Court judgment.
Lord, your review application on the ground that a review application is pending before your lordship, Lord, because your lordship in the circuit court at the relevant time, we could not get it hard. Therefore, Lord,
Review application before?
my lord,
Here, what review of what order?
Lord, regarding that stamp duty assessment of stamp duty.
Oh,
Because-
stamp due. Oh, that
Yes.
is, it is that matter.
Yes.
But here,
Lord, in
Mr.
view of the dismissal of the suits, that review application, we are not in a position to move. Difficulty is there.
please consider that 227 is not maintainable. I can give you leave to prefer a Order 9, Rule 9 application.
Lord, let it be adjourned today, Lord. And if your lordship, Lord, fix the review application with this, then Lord,
It
purpose.
cannot be done. Once the suit has been dismissed, how can it be done? If it is not restored, nothing remains in that.
Then your lordship, kindly, my lord,
The question, the question that falls for
same with that.
consideration is whether yes, call the next matter.
Matter number 25,
Passover. Next.
matter number 26,
What I'm for the petitioners, defendant in a suit for eviction of a trespasser, confirmation of possession and recovery of cash possession. And what has happened in this particular matter is during the pendency of a revisional application before your lordship, the learned court was pleased to close the cross-examination of the PW1 and fix the yes.
30th of July, it has not been closed.
No, that was
30th of July.
no, that was closed earlier during the pendency of the earlier revisional application before your lordship.
Yes.
Now, by an order of 11th of June, order number 104, I have also enclosed that order in your lordship's brief. Now, by dint of that, during the pendency of that application, that was closed. Subsequently, your lordship was pleased to dispose of the revisional application.
Yes.
Immediately took out a recalling application. That is enclosed, your lordship. Now, that is at page
So
19.
now it has been fixed for further cross-examination of
Yes.
PW1 on 30th of July.
Yes, it was yesterday. But I'm aggrieved. Yes, I'm aggrieved with the latter portion of the order, your lordship. Your lordship, if your lordship kindly comes, I have taken out an application in the learned court to that extent also. And if your lordship kindly comes to,
Yes.
therefore in view,
Therefore, in view,
yes, of the aforesaid observations of the Honorable High Court, it is crystal clear that the conduct of the defendant is not at all satisfactory. However, in the interest of the proper adjudication, the instant petition for recall of order number 104 dated 11/6/2025 is allowed as a single chance, subject to payment of compensatory cost of rupees 3,000 to the plaintiff.
yes.
Now, the imposition and levying of this 3,000, I'm not on that. But with the imposition of this compensatory cost, well, it is altogether a different concept. To impose
35B.
court could have gone under 35B. Court meant actually 35B, but I was imposed with compensatory cost. Now that is the problem, my lord, because the court is actually not appreciating this.
Bhattacharya ji, enough
35.
indulgence has been given to your client. Unless you pay, you face the consequences.
No, we have taken out an application. We will.
For recalling of that.
No, we are only before your lordship because this will actually operate in a subsequent proceeding also. That can be because there are other proceedings also. When before lordship kindly takes 35
Mr.
A once.
Bhattacharjee,
This
30th
is
of
the
July, what did you do?
No, yesterday, it was yesterday in the trial court. The court was not in session.
So the next date fixed, please cross-examine that.
Yes, yes.
Have
yes.
you put in the cost?
No, we could not because the other side did not choose to take up because the court was not there. We insisted. But we took out an application to the court that we are absolutely interested to cross-examine because then our right will be waived.
With regard to the cost?
We are interested, but because we have chosen to come up with a revisional application before.
What?
Only for modification of this particular compensatory cost. The term, I am after the usage of this term, my lord. Because it is
compensatory will be modified only as cost.
Yes, that is only the extent, my lord, because otherwise 35, a court has gone after 35A 1 and 2 and 4. If your lordship kindly takes up 35A once, if your lordship kindly takes up 35 once, because there has to be an actual finding to the before the learned court that the defendant has taken out a false defense before the court, which would otherwise prejudice the plaintiff, and subsequently the defendant has either withdrawn or abandoned that claim. Well, that is altogether a different thing. That will affect my trial. We are at the very, very beginning of the commencement of the trial. And if your lordship, kindly takes up 35A4, 35A4, 2.
So, Mr. Bhattacharjee, do one thing.
Yes.
Pay the cost.
Yes.
I'm keeping this pending.
Yes.
I'm recording that.
We have taken out an application before the court yesterday also.
Pay.
Yes.
Taking out an application
Yes.
will not do.
Yes.
I'm keeping it on for us.
Yes.
So, please pay the cost first.
But the cost is not being accepted, your lordship. The other side is not at all in a mood to accept the cost.
Why?
We do not know. We fail to understand. Because the court,
they are not happy with the cost. They want enhancement of the cost.
Yes. Then the court can impose any cost under 35B. But under 35A, there is a stipulation, whichever is less.
No, where it is, how do you say that it is 35A and not 35B?
Yes, 35. If your lordship kindly comes to 35A once.
Yes.
This order has been passed under 35A in the garb of 35A. If your lordship wants comes.
But do you find that it is under 35A?
Yes.
But do you find that from the
compensatory costs in respect of false or vexatious claims by plaintiff, by a party?
That has not been said there, false and vexatious claim.
But if your lordship goes by the tone and tenor of the order from the initial part of the order, number 105.
That is cost for causing delay.
Yes.
Cost for causing delay.
Court made 35B because 35B is about that. But the court has gone by, we have said this to the court also.
So I'm observing that it is not under 35A, it's under 35B.
If your lordship does that, yes, your lordship. Because otherwise, my 35A4 will affect my other proceedings also.
This application under Article 227.
There is a caveat. There is a caveat.
I'm dismissing your application, how they will be affected.
Yes.
No adverse order. So this is adverse against you, not against them. I'm recording. Mr. Bhattacharjee, learned advocate. Yes. Yes.
For the contesting, my lord, opposite party, if a copy can be served to me.
I will.
I know the urgency. I will, my lord, I have a date
Ma'am,
fixed for execution tomorrow,
may I-
naturally the urgency.
May I just complete, my lord? If there is no caveat, if there had been a caveat, I will.
No, lordship still, my lord, allows this, my lord, whenever there is a, my lord, opposite party representation, my lord, direct, my lord, let them serve.
Why will not?
It's surprising my learned friend has it. Petitioner has it,
May I-
contesting
if
opposite
your
party.
lordship, if your lordship see once, my lord, the matter, my lord, lordship will kindly hear me for 5 minutes. Kindly state. But against an arbitral award, a section 34 has been filed. Now, but there, my lord, an application for stay has been filed. Kindly turn to page 88 of your lordship's brief. Page 88. Kindly straightway come to. But before
Page 88.
88. It is in the first volume, my lord.
Yes.
But earlier occasion, my lord, the revisional application was filed. Now, my lord, what happened, my lord, that I have to secure the, my lord, award amount by a bank guarantee, and I was direct. There is certain terms and conditions. But there was an eviction decree also, my lord. Now, kindly see the order dated 14 June 23. Demand draft being number such and such have been produced before the court and handed over to the learned advocate on record of the for the opposite party number 1, Mr. Bose. Learned advocate has taken delivery of those demand draft. Cost of rupees 1 lakh shall be paid to the opposite party number within the course of June 15, 23. With regard to the prayer for payment of occupational charges from the date of the award, the opposite party number will be at liberty to approach the learned executing court for necessary order. If such application is filed, the same shall be disposed of in accordance with law. Now, with regard to the bank guarantee, the petitioner is directed to deposit the same to the learned court below by June 1923. The learned court below is requested to post the matter on June 2023 in order to ascertain the compliance of the order of this court. Although the matter has been posted tomorrow, so this and hence such request is being made by the court. Learned Judge Commercial Court at Asansol shall proceed with the execution case, arbitration case such and such expeditiously if the order of this court is not complied with. In the event of the compliance, the execution proceeding shall remain stayed. Now, this is the condition order. After that, we have deposited the bank guarantee. Now, we'll actually note the bank guarantee, there is some prescribed period time. Bank guarantee after that expired. Now, what happened, my lord? Against this order, they preferred an SLP before the Honorable Apex Court, but there is no stay order, nothing. Before the Honorable Apex Court, they filed an application saying that the bank guarantee has already been expired. Now, my lord, we have served that copy, we came to learn, then and then we applied before the bank, and we have total lordship knows, or unless original bank guarantee is returned, my lord, we are not in a position to renew the same. Now, what happened? Be that as it may. Now, my lord, we then and then talk with the bank, and your lordship knows now in view of the present guidelines, we have to again deposit the entire amount, then fresh bank guarantee will be issued. Now, what happened, my lord? We filed. Now, my lord, what happened? We filed an application. They filed an application before the executing court, before the SLP as well as the executing court, saying that look here, bank guarantee has been expired, but the condition was that I have to deposit 11 lakhs per month. That I am depositing, no problem.
11 lakhs.
11 lakhs. I have to pay that. I am paying, no complaint that there is a default. Oh, no, obviously. Now, what happened regarding the bank guarantee? They filed application before the land executing court that the interim order should be vacated. Now, I filed an application. Kindly straightway come to page 89, page 90. Second one. No, I'm sorry, second volume.
Second volume page.
Second volume order date.
189 application starts, sir.
Application doctor
Order is at 199.
199, my lord. But kindly see order number 20 dated 21st March 25. IA 3. Now, my lord, 199 you lordship filed. Fine, my lord. IA 3 of 24. IA 3 of 24 filed by them, my lord, for vacating the interim order as the bank guarantee had expired. Now, my lord, IA 3, my lord, have you lordship got it?
Yes.
IA today is fixed for filing in opposition by the petitioner to the application.
IA filed by them.
IA 3 filed by them for vacating.
Yes.
This, my lord, 21st March, I filed application IA 4. Kindly see, my lord, next. Petitioner has filed an application praying for acceptance of bank guarantee in terms of the order dated March 28, 23, passed by the Honorable Court, is registered at IA 4 of 25. By this time, new bank guarantee is with me. I filed application that
permit me to file the bank guarantee, accept the bank guarantee, and my lord, permit me to return the earlier bank guarantee, because there cannot be double punishment. They paid for time for opposition. Kindly see. Now, my lord, next date has been given 3rd June 2025 at 11:45. Then kindly see the next page, page 200. 3rd June, my lord, unfortunately, the learned judge was not in court. My lord, now, my lord, next date has been 12/8/2025.
Yes.
Now, what happened? By this time, execution was going on before. Execution case has been stayed by this honorable court, that is pending before the Asansol. They filed an application before the Asansol court for by a put-up petition, saying that, look here, bank guarantee has been expired. Therefore, kindly fix that date for execution. The court has fixed the date on tomorrow, executing court. Then and then I filed an application before the commercial court saying that, look here, this is the condition. They have already filed a put-up petition and execution course for delivery of petition and has been fixed tomorrow for hearing. And now, kindly prepone the date, because my your lordship has seen next date has been given 12/8/2025. By the impugned order, they appeared. They said no, preponement cannot be done because we have not yet filed the opposition. Now, by the impugned order, what the court has done, court has rejected my preponement application and fixed the matter on 12th August. Now, kindly visualize the impugned order, your lordship. Kindly see 21st July, page 202. Page 202. Kindly see page 202.
202.
Yes. This is my preponement application was fixed for hearing. Today is fixed for hearing of the application filed by the petitioner on 10/7/2025 for preponement of the date of hearing, which is fixed on 21/7/2025.
The bank guarantee is ready.
Absolutely, with the court. But bank guarantee now with me. Kindly, from today by 4 p.m. I will deposit. Today by 4 p.m.
I don't have a copy of the civil revision.
But
What has been, my lord, represented to your lordship?
May I just only one?
I opposed, my lord, the preponement, the application which was, my lord, moved by my learned friend's client. That is not correct because he was not there. Mr. Medora was there. That is one. Second,
yes,
my lord, the bank guarantee, my lord, when did it expire, my lord? That date has not been given to your lordship. My lord, they were enjoying an unconditional order, my lord, all this while. My lord, from the, my lord,
11 lakhs every month. We have
no, 11 lakhs is on account of something else. That is occupation charges. My lord, what is the, my lord, issue? In the award I get, my lord, it was, my lord, an eviction proceeding with mean profit. So far as eviction, so far as, my lord, the computation of mean profit is concerned, 3,63 and odds, my lord, bank guarantee was, my lord, the condition imposed. Initially, they gave that bank guarantee in the form of 3 BGs. My lord, that was to be kept renewed. My lord, they were aggrieved with an order passed by, my lord, the learned commercial court. A civil revision was preferred before this honorable court. Kindly takes, my lord, the language used by the, my lord, this honorable court when, my lord, the court extended the time for furnishing the bank guarantee. My lord, my first contention before the trial court was also this, that you cannot today come to the trial court and seek an extension. If at all you need you have a recourse, you have to come to the high court for appropriate recourse. That was my first submission before the trial court on the last occasion.
No, High Court, pursuant to the order of the High Court, they have filed the bank guarantee.
So, my lord, the order was very specific. Kindly takes the, my lord, order. I don't know.
88. Order of Justice Sarkar. Page 88. Before the learned commercial court, their submission is that one.
Mr. Mukherjee finish, then I will.
But you have made your submission.
My lord, kindly comes to, my lord, that order.
Seat. You have a chair behind you.
In, my lord, first page, last paragraph. Now, with regard to the bank guarantee, petitioner is directed to deposit the same in the learned court below by June 19. Learned court below is requested to post the matter on June 20 to ascertain compliance. Although the matter has been posted tomorrow, today compliance of this order may not be possible. Hence, such request is made. Next para. Commercial court at Asansol shall proceed with the execution, being arbitration execution case number such and such, expeditiously if order of this court is not complied with. In the event of compliance, execution proceeding shall remain stayed. Last line. Any default in payment of the occupation charges as already directed shall also amount to vacation of the interim order that is being passed by this court without further reference to the court. So, my lord, 2 conditions. One was BG. One was payment of occupation charges. Any default, I am entitled to, my lord, continue with my execution proceeding. One document I show from my application which I filed before the executing court Asansol. Copy it out.
So, Doctor, only one thing. 12th of August, it has been fixed before the commercial court.
Yes, my lord.
So I'm not saying anything with regard to that application. I'm recording Mr. Mukherjee's submission that the original, Mr. Mukherjee, give a copy to Mr. Doctor with regard to.
Question is, can he submit, can the court, my lord, today accept it? My lord, I want to show your lordship.
Mr. Doctor, 12th of August, because he wanted preponement. I'm staying it, I'm not deciding anything on that. Till 12th of August, I'm
That
staying
would
the
mean, my lord,
execution.
unconditional stay again.
Mr. Doctor, or I will decide that matter here and now.
No, my lord, kindly.
So that
My
is
lord,
why
this is-
I'm keeping that
I
open.
understand what is falling from your lordship, but lordship, please hear me, my lord.
One
When
application,
the BGs expired, this is very important.
Mr. Doctor, thresh out there. I'm not saying anything. Today we are on 31st of July. So 12th of August, till 12th of August, don't take any steps. I will not make any observation. I will only record the observation, submission that he is having the original.
161.
You have annexed.
Yes.
Yes, that has been annexed.
But
In
copy
page 161, I'm recording that.
My lord, kindly visualize. As an award holder, I am not at his mercy. Please realize this, my lord. This is very important for award holders or degree holders. My lord, as executing court.
Then, Mr. Doctor, there are two things. Then I have to consider this, I have to decide this, or I'm keeping all points open. Till 12th of August, I'm leaving the commercial court to decide on that. That can be vacated on
So
that.
in that case, my lord, give
I will
me
not
1 minute to
able-
just take instructions, but in that case, my lord, lordship will direct my lord preponement if I'll just take instructions.
Mr. Doctor, preponement.
No, otherwise it would mean I cannot accept the PG now because the application is pending before the trial court.
Mr. Doctor, I'm not saying that you have to accept. I'm recording that he is having the original. I'm recording his submission and the copy. He says he has copy has been annexed. I'm only recording that. I'm not saying, I'm not directing you to accept. All points will be kept. We decide on 12th of August, Mr. Doctor, because preponement, because I do not know the business of the court. So preponement, then I will have to give.
But till 12th of August, it means again, my lord, he enjoys unconditional because lordship is, my lord, referring it back to, my lord, the trial court. Till 12th of August, it is unconditional then.
Mr. Doctor, I have not said that it will be accepted now, without any observations. Everything.
No, but lordship will be staying. My lordship would be requesting me not to take steps because execution is tomorrow.
If you undertake that, I will report that and I will not do anything.
My lord gives me one. I have to just take instruction.
That bank guarantee copy has been served upon him on my lord.
Mr. Mukherjee, that is a different thing altogether. You are out of time.
May I step out?
So whether he will accept it or not, that is his decision.
Can I come back at 12, my lord? Just I'll take instructions and indicate, my lord. 12 o'clock.
So, and if you can undertake that he will not take steps till 12,
Yes,
or
I understand.
1 or 2 days till after that.
Till such time the trial court decide this application
Yes,
of it.
yes.
My lord gives me, my lord, 10 minutes. I'll
Because
just take-
preponement, Mr. Doctor, will be a difficult thing. Then I will have to give both of you liberty to approach there. Same thing might happen.
10 days, 12 days will not really make a difference, but I'll take instructions. I'll indicate to your lord. Gives me 10 minutes.
Yes. Tolerance matter.
My lord, I have the my lord, please.
You have instructions, yes.
আরে নামটা পড়ে দিবি ছাড় না বল না ভালো করে
My lord, the instructions are, my lord, if this amount, my lord, BG, my lord, again this confusion will arise. They want execution to be stayed. My lord, let them put in cash security for this entire amount. Let it be, my lord.
So that will be modifying that. Do that on 12th. Say that not BG by cash security. I'm leaving all points open on that because this will be modifying the order.
Very well, madam. We will deposit cash. Kindly permit us to withdraw the bank guarantee. Both the bank guarantee. Because madam, we can.
It should be simultaneous.
Mr. Doctor, that is why make that submission on 12th. I'm leaving all points open. I will record your submission. I will record your
Lordship,
submission.
kindly record this, that tomorrow I will not take steps in the execution. 1. 2, my lord, let the application filed by Mr. Mukherjee's client be decided by 12th.
Yes.
Let it be decided by 12 because pleadings are complete and the outcome will be, my lord, whatever I
Is here, you have filed your
I have filed.
Recently.
Yes, file, Mr. Mukherjee. How long it will take? You want to file a reply?
March.
Mr. Mukherjee, you want to file a reply?
We have already before the next day we will file.
So he filed, Lordship provides for that. before 10th,
Next day, so I will fix the time
Yes,
to
yes,
file
yes,
reply.
Give me 2-3 days time to just go through the reply, so that window should be there.
Yes.
And my lord, 12th of August, the learned court decides everything, only makes one observation regarding this cash security also.
I will record
The
your
learned judge-
submission and I will also record
Let
your
us
submission,
consider.
but I will not,
Don't formally stay it, record my submission.
yes.
On instruction.
On instruction.
Uh,
Monthly list. Item number 1037.
Yes.
There is the caveat and my lord, copy has been served, prior notice of mentioning has also been served.
What can be done today?
Plus, can it be tomorrow, my lord? Can it be done tomorrow?
Tomorrow, I do not know. Not today, next.
Item number 1103.
Not today, next.
Item number 1137.
Not today.
Item number 1188.
Not today.
Item number 1203.
But I am for the opposite party. But in this case, there is 27 crores due to the opposite party nationalized bank.
Not today.
This is the fourth time. Like tomorrow, some precedence may be given. Some precedence.
Not today, next.
Item number 1252.
Not today.
Item number 1272.
Not today.
Item number 1278.
Not today.
Item number 1282.
Not today.
Item number 1290.
You are appearing.
Petition.
There is any caveat.
Caveat was there. Thereafter I served the notice to the other side. They appeared.
Not today.
Item number 1294.
Opposite party.
Oh, I am appearing on behalf of the petitioner, my lord. There is another matter which may be tagged with this matter, my lord. I am led by
Item 517 of the monthly list. That is my application.
What is this matter? What is this matter?
my lord. We have challenged the quantum of the maintenance, my lord. I am led by Probal Mukherjee, my lord. If your lordship kindly and they have filed the revision for quantum. They have also challenged the quantum.
Right. So, in what can be decided? Yes. If all the papers are there. Yes.
Oh.
What do you want?
My lord, then my lord, kindly make it not today, my lord, where I am late by.
Lordship, if both the matters may be tagged together.
আচ্ছা ওটা করে দিন তো লিস্ট ওটা কত নম্বর 1394 no this is 1294
1294 lordship my
record করে দিন list is there along with
monthly list 517.
monthly list 517 এর CO নাম্বারটা লিখে দেবেন
I'll share the CO number lordship.
the
Yes.
CO number
আমি দিয়ে দিচ্ছি check.
yes next
Item number 1302.
যেদিন থাকবে
Lord, I beg to appear, Lord, for the opposite party in this matter. Lord, there is another matter.
not today next next
Item number 10.
not today next
Item number 1329.
not today
Item number 1344.
not today
Item number 1349.
not today
Item number 1351.
not today
Item number 1364.
Lord, in this matter, I appear for the petition. Mr. Mahato is appearing for the.
not today oh Mr. Mahato is here
Yes.
yes
Yeah.
Mr. Mahato
1349.
why are you so slow in coming you are not in a mood to do this matter
Lord, on the last occasion,
file is not here
it's a repair application, my lord, that was rejected.
repair application that has been rejected.
Repairing application, Mr. Mahato does not oppose.
No, my lord,
You are opposing. Why? At his own cost, he will repair.
honored judge has given the reason.
Repairing usually do not oppose.
No, it is not of such nature, my lord. Repairing should be allowed.
They are trying to change the nature and character.
But the
I am appointing your advocate on record as a
not in a position to be repaired. Structure is not in such a position which can be repaired. New construction is required.
No,
new construction has to be made.
I do not want any new structure. My lord, kindly have a look to my prayer, my lord.
My lord, kindly take it up tomorrow or 2 p.m. my lord.
Not today, next. Next.
My lord, tomorrow it would be called on.
That I do not. Tomorrow's.
I am suffering. My lord, I am suffering a lot.
137 for am for the
Kindly
opposite
takes it
party.
up at 2 p.m. my lord, at least. My lord, on the
Next.
my lord, last occasion he said no notice was served. Now this time notice was served. He is present.
The resolution is different. My lord, kindly make it short password.
1374.
Kindly make it short password.
At least.
1374.
Yes.
Opposite
You are.
opposite party.
What is to be done, Mr. Mukherjee?
But truly speaking, this order is required to be sent back remand.
Send back on
Remand.
remand.
But my petitioner is not there. Petitioner is not there. Mr.
The
Parthavardhan.
law is not there. You are agreeing to that. Not today, next.
Item number
But my matter
1433.
kindly make it pass over. My lord, Mr. Mahato is coming back.
Next.
Item number 1433.
Not today, next.
Item number 1531.
Lord,
No.
143.
Yes, 1433 was called. 1435. Yes.
1433.
153. I am appearing for the respondents, my lord.
1433 na 35. 1433. Yesterday it was called. Yes. 15.
1531.
Not today, next.
Item number 210.
My lord, I am there.
Yes. First time or after service.
No, my lord, no caveat, my lord. Expeditious style, my lord.
Expeditious trial.
We are the plaintiff degree holder, my lord. Suit for eviction, my lord. My lord, application for expeditious hearing of the title execution case, my lord, in connection with eviction should degree of the year 2000 suit. Eviction, my lord. An title execution has been filed, my lord. 2013.
Eviction suit before the consumer forum.
No, lordship. No, lordship.
কোনটা দিলেন?
210. 210.
Item number 210. What is the name of the party?
My lord.
427
Khatun.
দিয়েছেন।
Ashraba Khatun, my lord.
4272 দিয়েছেন তো।
4276.
আচ্ছা Passover wait. We call now. Yes, next.
Item number 368.
1364.
368.
368.
Not today, next.
Item number 386.
My lord, this is my application, my lord, from an order of the commercial.
First time or after service?
First time, my lord, no caveat.
No caveat. Then
My lord, here, I'll just tell your lordship the background in one moment, my lord. There are two suits. My lord, CS number 52 of 2024, that is filed by the state. CS number 54 of, I beg your pardon. Yes, 54 of 2024, that is my suit. They're both arising out of the same transaction. Contract had been given to me by the state, my lord, to collect toll on a bridge. Immediately after giving me the contract, immediately after giving me the contract, it transpires there is structural fault in the bridge. So they shut the bridge down. And my lord, not entirely heavy earth moving vehicles, etc., which generates the maximum my lord toll revenue, that is shut down. So that does not ply on the bridge. My collection is affected.
What is the impugned order?
Impugned order is, my lord, lordship will find at page 110. Yes, my lord. My lord, I am led by
12A was granted. He prayed for Miller in a suit for damages. There can never be urgency.
কি দিচ্ছেন বলুন তো, এটা 7C 7C দেখছি তো কি ফাইল দিলেন রেমিসটেন্সি অ্যাক্ট 7(3)
ওই আমার মতন উকিল দেখে তাই জন্য 7C দিয়েছে, কিছু করার
because your appearance I was thought that it has to be
order 711. Your lordship would have thought it was order 711. That's
also
what
section
that's
7(3).
that's my lord's observation.
Yes, that's there. I'm not withdrawing that, but 7(3) also now. 12A does not come in my mind.
Doesn't come. Those are for Shaib is there, Miller.
All right, let me take 5. বার করে নিন সাজিয়ে নিন কি
Lord, can we take up the plaint once?
The Chatterjee, what have you annexed in this?
Unusual.
So which is the volume from which you will refer to the একটা volume
One
দিতে পারছো?
and 7.
1 আর
7.
1 আর 7টা দিন বাদ বাকি রেখে দিন।
My lord, for the time being, Lord, for an interim order, Lordship takes up the impugned order, that should be enough. Or your Lordship need not even take up the brief, I'll tell your Lordship. In a suit for damages, in a suit for damages, they have claimed a certain amount of money. I also have my own suit for money, my lord, from them. Clause
counter claim.
No, not different suits. Then they applied for, my lord, clause 12A leave. That leave was granted, my lord, on a my lord, suit. On a suit for, that's why I say, on a suit for damages, the court allowed the order 12A leave and granted the leave.
Urgent interest.
We prayed for, my lord, recalling, saying that there is no urgency. If there is no urgency, 12A, my lord, is mandatory, that's party automation. The court says there is urgent relief. In a suit for damages, may I ask this question to myself, there can never be any urgency. My suit, pre-mediation, everything complied with. Moment they saw this was moment they saw, me that I will file a suit, they went ahead behind my back, filed the suit and obtained the leave. This is the matter. There's nothing beyond that. Because all the contracts have been annexed.
Tanmay Mukherjee is here, no. Similar point I have heard.
Lordship heard.
12-way, I think also money suit.
Yes.
More or less same.
In a money suit, injunction, my lord, comes in by way of Mareva injunction. But here, my lord, he has said that I want 38 crores or say X amount of money. That needs to be adjudicated.
What is any application for urgent relief has been filed?
See, that's what I'm saying. You know, there's no question of an urgent relief.
No, any application filed. Question is different.
They filed order 38 rule 5 application way later. Why I tell your lordship there is no urgency is kindly see paragraph 38 of the plaint. Have a look at just that.
Which volume?
First volume. And sees me not page 39. I go বাধা আছে একটু কেটে দিলে হয়তো কেটে দিলে
কাটা যাবে না কেটে দিন না তো কেটে দিয়ে আস্তে আস্তে দেখে কাটুন নাহলে পুরো impugned order is in this volume.
No,
7.
Look to Lord, paragraph 38.
No, impugned order is dated 21st of May 2024. What is the date of the impugned order?
6 December 2024.
6/12/24.
6/12.
Lord, your lordship goes there later. I'll take your lordship to the cardinal thing first and then.
Plaint is in which volume?
First volume.
First volume.
It
Yes.
starts off from somewhere, my lord, but takes up paragraph page 39. Starts off from 27, takes up 39.
39, yes.
Sees paragraph 6, first line.
Page 39, paragraph 6.
36. 36. Paragraph 36.
Oh, paragraph 36, yes.
That the cause of action for the instance suit arose on and from 23rd August 2023.
Plaint
Just
filed in May
get
24.
clear for the moment.
May 24 plaint filed.
And the plaint is filed, my lord, in May 24. Your lordship need not see anything else.
Now, Mr. Chatterjee, have you gone through that decision of
Party
the
automation.
Supreme?
Party automation.
After that, considering party automation and other things, because the view was that whether there is contemplation of urgent relief that was explained, said that it has to appear from the plaint itself.
Absolutely.
But there's a subsequent judgment which says you may say that there is urgent relief in the application itself. 12-way. In the 12-way application may not be in the plaint itself.
No.
That's the in the 12-way application they have what they have stated.
12-way application.
Page. Now show me the impugned order. What is the impugned order?
Below that 12-way was granted, we paid for recalling. That recalling has been refused.
1108 volume 7.
Then Mr. Chatterjee, where is the question of interim order now?
Below the stay of the suit. The suit
Stay
can
of
proceed.
the-
My lord, if my order is recalled, if 12A, my lord, is recalled, the suit can be instituted.
Trial stage.
That I appreciate. What is the stage of the suit?
Trial. Evidence is on.
Affidavit of evidence. Is last order.
And have you considered the
12th
division?
of August. 12th of August is.
Have you
the final
considered the
evidence.
division bench judgment of our court?
On?
Justice Mukherjee on this 12A.
Supreme Court
Yeah,
last.
Manohar is the one, my lord, which holds the field right now.
Supreme Court last decision.
Yamini Manohar is the last party.
Yes, I think in Yamini Manohar, this has been said in 12A.
Absolutely.
But our division bench has said, have you considered those
The Supreme
judgments?
Court is there, my lord. It's. No,
Considering Supreme Court and other things.
I tell you, Lordship, Lord, it can't be. The statute is clear. Whatever the Supreme Court says, whatever the High Court says,
No, I think Justice Padiwala's judgment is there. What's the reference?
comes from
Where is that? On 12A.
Yes, yes. Nothing is
I
against
think
me.
here 12A, it has been said that you may not. Yes, 2025 SCC online.
My lord.
Paragraph
Dhanbad 12, yes.
62G.
62 that holding the G to specifically.
Paragraph 62.
The findings of the paragraph G টা যদি দেখা যাবে ওখানে clearly বলছে
Courts must also be wary of the fact that the urgent interim relief must not be merely an unfounded excuse by the plaintiff to bypass the mandatory
So where is that paragraph which says that you can also explain it in 12A? That's a distinction which is being made. After party lot automation, it was considered.
D, if your lordship thinks that party lot automation is considered in C.
Yes, party automation is considered in paragraph 54, 54, 55.
Look, those are the ones which are there on the body. The conclusion.
Yes, conclusion is there. No, I am on the body. Body there is, if I faintly recollect.
But even then, takes it for granted, my lord, it's there. Takes it for granted, the urgency is there.
whether it is illegal.
No, I asked this question.
And this is a suit pre or post party automation.
Post.
This
is 22. This is 23.
Party automation.
20.
So it has to be from that date, 12th of August, I think, or
My lord.
2022.
And this is a very germane thing here. You can't, my lord, 12A party automation says is very, very mandatory.
Show me the reasoning, what the.
Impugned order.
Yes.
একবার দাদা এই abhorrent 1108
Yes, Mr. Mukherjee, 12A, what are the decisions of our court division bench?
Yes. সৃষ্টি আছে আর গ্যাব্রিয়েল বলে সব আছে Yamini Supreme Court.
Srishti, I think, yes.
But after Yamini Manohar.
This is Mukherjee's judgment, yes. Yes.
Now, can you see the impugned order says that the plaintiff's accompany. Have a look at it. 296 impugned order.
296. 6th of December 2024.
The 12A order. 1108 dada volume 7
1108.
Yes, it's to 1108. I'm sorry, it's my fault.
Why, Mr. Chatterjee, you have not filed the certified copy?
It should be there, no?
1108 page number.
But they make a mistake. No, it's a certified copy. They should not have marked it.
This is a certified copy. No.
You can't touch it.
No. It's a Xerox photocopy of this. In the in my copy, it's a photocopy.
It's there on the top, right at the beginning. It's there.
Certified copy is at the beginning.
At the beginning. These days, that part probably has changed.
Certified copy is the beginning. No.
Beginning,
Certified copies, photocopies are given in the beginning.
They have probably made it other way around.
No. That is also the certified copy. It's a photocopy.
Original ta kothay? May I once look into it?
I have only 2 volumes here.
The last
First and last. It is the last, na. What is the last volume?
Seven.
Seven.
7 টা তো আছে। একটা 7 দুটোই দিন না। Volume 7 টা last.
আবার কি করেছো? এই তো আছে। এটা কত নম্বর? আচ্ছা।
In which volume?
Volume 1.
Volume 1.
Yes,
Without the certified copy file, they will not take. Without if I have not taken the leave of my lord.
Yes.
Now kindly have a look at
Paragraph 3 তে দেখানো আছে 82 দিন ওয়েট করেছে after participating in final. Paragraph
7.
Paragraph 7.
Yes, and he has considered all the judgments.
Yamini Manohar considered paragraph 8.
Srishti, Yamini Manohar,
Srishti has been considered.
Considered.
Which paragraph? Yes, Yamini Manohar has been
And then
considered.
turns to 11. 11.
Gabriel Mittal, Srishti has been considered.
Now sees the observation at 11.
Yes, based its decision on Srishti. That is why I told you there's a decision of the
My lord.
division bench.
Absolutely. But it doesn't affect me. I am saying, my lord, that whether 12A is mandatory or not, it is. Whether 12A
There is no dispute that 12A is mandatory. There is no dispute with regard to that.
Facts finds that on the whatever plaint has been filed, there is an urgent application along with it. Moment there is an urgent application, but 12A can be bypassed.
It cannot be granted.
Huh.
Illusory.
Mr. Chatterjee, this observation in paragraph 11 is in tune with, I think, if I faintly recollect, observation in Srishti. Same thing happened. Same thing there also says, yes, urgent relief may not have been sought for, but this is the nature of the suit, exactly paragraph 11.
Can you see the nature of the suit? I don't have to go anywhere. It's a monetary claim where it's not even been quantified.
I think Srishti was also on monetary claim. I think. Do you have Srishti? Do you have Srishti with you?
Yes.
Please give me. I think that was also on monetary
said,
claim.
why would your lordship look into a division bench when the Supreme Court is something different?
Yes. Please come. You need not give me that judgment. That has been quoted, paragraph 10. Please kindly come to next page, page 7 of the impugned order.
My lord.
You will be finding last effective paragraph on the basis of the declaration.
Yes.
On the basis of the declaration.
The plaintiff should be allowed to present the plaint.
Next, you can skip. No, sorry. Next subparagraph in this case. 7-8 lines below that.
Yes.
In this case, although the claim is monetary.
There is a pleading that since the defendant is incurring heavy losses, some urgent
may be sought.
There is nothing sought.
There also, Mr. Chatterjee, nothing sought. May be sought. That was the observation.
Then that's an application. My lord, if your lordship.
We're reading down.
Very good.
So this is the observation. Do you have Srishti here?
Why would your lordship, may I ask this question to myself, look into a division bench when the Supreme Court says something different?
Supreme Court says cannot be illusory.
That is the.
Would your beloved, with a lot of respect, is the division bench?
Yes, paragraph 34.
I completely.
There also no urgent relief was sought for. The Honorable Division Bench observed no, may not be, but may be sought. That's in future.
Whenever he says, can't be the law.
So this is the.
I say, my lord, if your lordship wants to rely upon that, it's for injury.
Mr. Chatterjee, what the trial court can do. The Division Bench is here, apt on the point that is there. Facts. On facts, that is also a money suit. This is also a money suit. And it says, even though not claimed in the plain, may be sought. So pat on the point.
May be sought. I am praying for recalling, saying that it hasn't been sought.
No, you said thereafter it has been sought.
I have an attachment application.
Have you seen the facts of Srishti? Same.
I am not even.
gone through these
I
judgments
found-
while I was hearing a different matter. That is why
I shall come to that. I'm এটা জজ সাহেব একটু রাখছেন খেলতে দে কোনো অসুবিধা নেই। Now, my lord, what happens is there can be a situation that in a monetary
serve, they let them come.
Carry stays the suit. But I will, when I make my submission finally, I will try and tell your lordship that I did that in that matter which your lordship released. In the matter which your lordship released, because Mr. Bhattacharya was appearing. In that matter, everything was argued threadbare before your lordship.
No, in the other matter which I was telling, that is of steel, no, not steel, Coalfields Limited. So Mukherjee was on one side and Mr. Debnath Ghosh was on the other. Both of them appeared before the commercial court also. Both of them appeared. Though both of them said we did not physically go, we were, they said that. That's the other part. So there also exhaustively it was argued.
You know, Mr. Joydeep Kaur on one side, I was on the other
Yes,
side.
yes.
We argued it to the hilt. But the problem
That
happened
I
later.
was, and I was about to, while preparing it came to my mind.
Yeah, I would say, my lord, and my learned friend is right. Srishti carves out an exception. And Justice I.P. Mukherjee, knowing his lordship very well, my lord, he was more inclined to pass an order, my lord, in favor of the
No,
whatever.
Mr. Chatterjee, with regard to the precedential value being the, has to be being a division bench, it has to be, I'm bound by that.
No, your lordship is bound by the Supreme Court even more.
Yes, that's a different thing. So
Supreme
that
Court
is to be.
different, my lord, your lordship would not even look at the division bench. And he says, my lord, on the basis of the declaration that urgent relief is contemplated, the plaintiff should be allowed to present the plaint. The court should not ordinarily interfere with such assertion unless it is shown to be palpably erroneous or malafide.
I did.
Show Yamini, my lord, which is Manohar Bodhai, which is basically says it's mandate from party automation.
No, mandatory, everyone has said mandatory. And contemplation has also been explained.
Justice Pardiwala says it can't be illusory.
Yes, yes.
Can't be illusory.
Yes, but
I just say
I
that
think
you
it
can have an application.
not exactly recollect either in this judgment or in another judgment where it has been said, because all the decision says from the plaint it has to be seen. But in that decision it says may not be in the plaint. In 12A, if you can explain that.
But if a litigant files a suit in 2023 and files an application in 2024, that can never be, my lord, an urgent application. Never be.
Cause of action 2023.
I may
but
write
may-
whatever I want to in the application, but by conduct, my lord, he's stopped from saying.
That is what you are saying is that from the bare reading of the plaint, it has to emanate that there is
Not just
urgency.
of the plaint, my lord. Plaint and thereafter.
Because similar as in ad interim injunction also.
I bow down.
More or less, I am not saying that.
Absolutely.
So whether you are entitled to ad interim or subsequently after notice,
absolutely,
whether notice can be dispensed
Bow
with,
down, my lord.
the test may be the same.
Absolutely. I completely bow.
Cause of action and suit.
Now, sees the conduct here. 23, he says the cause of action, files a suit in 24, doesn't move the attachment application immediately. Doesn't.
And prior to
And this can never be, my lord, a situation where there is extreme urgency.
3 months prior to filing. suit.
By the impugned order,
My
recall was rejected. Ashun. That matter, Mr. Chatterjee, hearing concluded.
No,
This
could not
will
get it here. Could not get it here. It was assigned before Justice Shortcut, could not get it heard. Order 39 Rule 1 and 2 disposed of, asking me to pay 18 lakhs. My application for recalling is still pending.
I was thinking if there is some decision, then my work will become easier.
No. The Supreme Court, I'll show, my lord, they are very clear. Very clear.
I think most of the decisions were cited, a compilation was given.
I
So you can also work out on that. There may be other
whenever your
judgments
lordship
also.
pleases, my lord, fixes a date, I'll get all that in a bunch and show it to you.
By the order impugned, you filed an application for recall or
Application for
the application paying for recall of the leave granted under section 12 capital A of the Commercial Courts Act 2015 stood rejected. First up, after going through the averments made in the plaint, this court finds that the cause of action for the instant suit arose on and from August 23, 2023, and the suit was filed on
21st May 2024, the suit was instituted. 21st
May,
May
and the suit
2024.
was filed on 21st of May 2024.
Yes.
First up, the question that arises for consideration is whether under such circumstances it can be the question that arises for consideration is whether the suit of present nature this question that arises for consideration is whether on the basis of the averments made in the plaint leave under section 12 capital A of the 2015 Act could have been granted, could have been sought for and granted. First, a petitioner is directed to serve a copy of this application upon the opposite party by register speed post with acknowledgement due and file an affidavit of service on the next date. First up, there shall be an order of stay of all further proceedings in money suit within bracket com number 52 of 2024 pending. State is the other side.
Yes.
State is the other side.
It is a plaintiff.
Could have served and then could have been made. Hearing could have been completed. That is the short issue.
Short issue, my lord, your lordship fixes a short date. I don't know. Anytime, your lordship. Because they want the evidence to be, my lord, given on the next day.
What is the next date fixed?
12th August.
12th. There shall be an order of stay of pending till the end of the month of August 2025 or until further orders, whichever is earlier. List this matter under the heading, list this matter in the list on after 2 weeks. Correct.
After 2 weeks will take us to, my lord, 13th.
13th, 14th.
Yes.
Because this is the short issue.
Yes. Just those judgments, my lord, nothing. Because your lordship need, my lord, I don't know why they are so, my lord, eager to make this brief bulky. What I'll do is, my lord, I will take out the documents which your lordship
serve upon the opposite party as well as the learned government pleader, High Court, Calcutta, and file an affidavit of service. ठीक है, sir? Except state, any other party, no.
No. State is a plaintiff.
Yes.
Because they don't want to pay me money, my lord. They've gone and filed this suit for basically counterclaim.
13th, how are you placed?
I have no problem.
This is not Friday the 13th. It's a Wednesday.
I have no problem.
13 तारीख 13th August 4 PM 4 সময় ফাঁকা আছে তো
It is state আসবে
4 PM
4 PM. Lord, 13th is not a Friday.
That is why I have told you whether you have any problem in
My interim order is there, I will never have.
no Friday the 13th, that is why I asked.
Those days are gone. Friday the 13th. Nobody is afraid of.
Yes.
They are more afraid of humans than the ghosts.
Yes.
10.
210. Yes.
My lord, where the plaintiff degree holder, my lord, suit for eviction, my lord. My lord, one title execution case was filed, my lord. Thereafter, my lord, my lord, judgment debtor filed an application under section 47 of the CVC, my lord. Only dragging my title execution case, my lord.
No, what happened to the miscellaneous case number 36 of 2023?
My lord.
What happened to miscellaneous
Pending, my lord. Pending, my lord.
36 of 2023 is pending.
My lord.
So
They have filed as,
that is
they have
section
filed,
47.
my lord, section 47.
That is to be disposed of first.
My lord,
This
no,
application under Article 2.
my title.
Unless
This
this
of
case has to be
starting case, my
decided
lord.
first. This case has to be decided first.
My lord, but both the case kindly.
Sir, if the miscase is allowed, your title execution will go.
My lord.
If the miscase is allowed, your title execution will go.
Well,
This application under Article 227 of the Constitution of India is at the instance of the decree holder. Not today, next.
529.
Time for the petitioner.
First time.
Second time.
Second time service.
Service, my lord.
Not today. Next.
Item 751.
Not today, next.
5765 lawsuit. I am appearing on the defendant.
First time, second time.
First time speedy for direction for speedy disposal lawsuit. I am the defendant petitioner lawsuit. Last 9 years suit for service stage in the stage of service.
In the stage of service. Then what
last
can be done?
Last 9 years lawsuit.
You take steps.
The difficulty is that I in the present suit challenging the decree passed.
Which defendant is you?
They are now not defendant number 2, 4 and 5.
You are the defendant number 3.
1.
No. You are defendant number 3 from the cost title you have stated.
Yes, defendant number 3. I am the contesting defendant. I got the decree earlier. That decree was challenging the present suit. So I cannot enjoy the decree lawsuit.
There is no stay, sir, here. What prevents you from enjoying the decree? Nothing prevents you from enjoying the decree. This application is under Article 227 of the Not today, next. You are appearing.
Yes, 1388, my lord. On the last occasion, your lordship was pleased to dare this site.
Direct
Service of
then, Mr.
No, my lord. In fact, I'll tell your lordship, this is from an order rejecting a Section 5 application in connection with an appeal by Debt Recovery Appellate Tribunal. My lord, Miss Aparajita Rao appeared on behalf of the bank. In fact, she was here right now.
Here, Mr.
No, she was here. She was here. I have spoken to her. So they have been served. This is all I can say.
But you have taken a resolution, Mr. Bose, today.
Yeah, of course, we have.
So, unless you can bring your other side.
I could, but there she is here.
My lord,
Yes.
only one thing.
They authorized of
Mr. Bose, he is not having a copy also.
I know.
Not only that, my lord,
The authorized
they
officer.
have not received anything. My lord, I've just spoken because he was kind enough to tell me. I called them up, they have not received anything.
So
What is the dispute?
Section 5 application in connection with an appeal. Before the
Rejected.
debt recovery rejected.
Cannot be rejected, Mr. Bose.
No, of course it can. Not on the grounds on which it has been rejected.
What is the ground on which?
My lord, I said that, my lord, I am not going behind the decree. Naturally, I cannot. The decree was passed. I was one of the party in the suit. I am not a guarantor. I am not a borrower. I am a third party. Be that as
What
it
is the
may.
period of delay?
No, 81 days.
No.
Acha, very well, 200 days. Now the question is that what the debt recovery appellate tribunal does is, he said 81 days in the first paragraph of the impugned order. What he does is, he goes and looks at my negligence, my conduct before the decree was passed.
That cannot be done.
So
that cannot be
my sufficient cause that I show after the decree was required to be considered by the appellate court, not what happened before that. That's the only reason.
Objection I would take is the maintainability of the civil division here. My lord, this is a matter which arises out of a judgment passed by the Debt Recovery Tribunal at Hyderabad. Now, no doubt, my lord, the appellate tribunal is in Kolkata.
Yes, Mr. Bose.
That
What do you say? Yes, I get you.
Well, kindly
So the High Court at Calcutta or the High Court at
no, Debt Recovery Appellate Tribunal Kolkata is exercising jurisdiction, and Debt Recovery Appellate Tribunal
yes.
Kolkata is under the supervisory jurisdiction of Article 227.
Mr. Bose, I appreciate the problem. The tribunal is at Hyderabad.
Correct.
Appellate tribunal is at Kolkata, exercising appellate jurisdiction over Hyderabad.
Yes.
Now,
Yes.
27 will lie here or Telangana.
My respectful submission is here.
You have authorities on in support.
No, my lord, I'll tell you, Lordship, why, my lord, we may not require authority if I can otherwise satisfy you, Lordship.
Mr. Bose, I tell you, I've heard a matter on this.
Oh,
judgment.
2 and 227, my lord.
That's the distinction. There are judgments
Yes.
of our court also, Supreme Courts on different aspects, and Supreme Court mostly on 226, I tell you.
Yes.
I think one judgment of the Supreme Court in 227, our court on 227, distinguishing 226 and 227.
Absolutely. So there is no dispute on the fact that
it has been held. No, not here.
No, what I am saying is that there is no dispute.
Mr. Bose, I tell you, the jurisdiction will be decided on the basis of the citus of the tribunal, not the appellate tribunal. That's the distinction.
No,
if you come to 226, you may say part of the cause of action. Their parts arose in Telangana, part arose in Kolkata, not in 227. It's a supervisory jurisdiction over courts and tribunals within the jurisdiction of the state of West
Now, my
Bengal.
lord, if your lordship will...
This hurdle, Mr. Bose, you have to cross. If you are ready, you can make your submissions.
So naturally, I was not ready on this. So your lordship keeps it any day, we'll address only on my...
These matters every day. You must be knowing that she will be taking this point.
No, he did not know I will appear.
No, man, I expected she will appear. No, but the jurisdiction, there's one judgment while discussing 227. The jurisdiction and the distinction between 226, 227.
Mr. Bose, I tell you.
I'm coming to that. Then, my lord, what would be the territorial jurisdiction of a constitutional court exercising jurisdiction under 227?
Yes.
Yes.
Yes,
that is, my lord, your lordship will see in India now, in our country, appellate tribunals are located in jurisdictions which has
I think 34 or 37 tribunals, 5 appellate tribunals. I'm giving you this figure from a decision of the Supreme Court. That is why I'm telling you. This issue has been considered, Mr. Bose.
So, and
34 or 37, I do not exactly recollect, is the number of tribunals.
Correct.
Debt recovery tribunals, 5 appellate tribunals,
Right.
exercising appellate jurisdiction over this 34 or
Yes,
37.
yes. So now
So
if
this point was considered by the Supreme Court also.
and my lord,
Mr. Jishnu Saha appeared.
Yes.
In the matter. And other side.
I'll find out, my lord. I'll find out, my lord. My respectful.
With the help of Mr. Jishnu Shah.
I will do that. I'll do that. I'll do that.
Relied on some judgments.
Very well.
In support, and I will tell you, there are other statutes also.
Yes.
Because initially I took, when this matter came up, not this matter, Mr. Shah's matter came up for extension of
SEBI Appellate Tribunal.
I raised this point, and then Mr. Shah said yes, because under various, not in these statutes also, other statutes also, Income Tax Act.
Yes.
So assessing officer within one state, appellate tribunal in another state.
Right.
Supreme Court has decided all that. It has to be the jurisdiction based on the assessing officer. It's the parent one. Because really, that order is being assailed. You are interfering with the order of the parent.
No, here, Mala, I'll tell you, Lordship, the distinguishing feature in this facts. Well, here, Section 5, had I challenged the order of the appellate tribunal confirming the order of the debt recovery tribunal, which is outside the jurisdiction, would have been otherwise.
Mr. Shah also tried to make that same distinction. Also
So,
tried
has
to
your
make that same distinction.
If I may,
by relying upon that decision. So same distinction, he says, if the nature of the order
yes,
would amount to directly interfering with the order. So he made a distinction if it was a final order
yes,
of the appellate tribunal, then yes,
correct,
but not an interlocutory order. But there lies something. So the forum will depend upon the nature of the order. Interlocutory order can be challenged at Kolkata, final order in Telangana, maybe another order, some other, in the meantime, some interlocutory orders passed, maybe not Kolkata, some other appellate tribunal for some time given that jurisdiction. So before that stay, it will move around. Please think of that situation.
So, your Lordship has not decided that point on Mr. Shah's 227, my lord?
Till now, not.
Okay.
But very soon I am.
Very well. So we will also add to that, my lord. So this issue, once we address your Lordship on this issue.
That's the only issue because no, merits is a different.
No, I am not on merits.
I am a very pertinent point of jurisdiction.
Correct.
Because I will ask you not to, because in that matter also, I've only heard on the maintainability, not on the merits. Because I have requested both the parties not to argue on the merits. Because maintainability, if I will decide only if I hold, yes, it's maintainable, then otherwise everything will lose.
Absolutely.
So whether the appellate tribunal could go beyond that date or not, that is the subject matter of other consideration.
Lord, can we come back next week?
Madam, do you have any decision in your support of this?
Anything. When he told me initially, I thought the 226, 2 and 226.
You are having those decisions.
One decision I had, and there's one a lot of our High Court.
Justice Bhaskar Bhattacharya's judgment. Yes. That's the judgment. Pat on the point.
On
this,
as a 227 court.
Yes, 227.
On 227. Other judgments are basically on 226.
And there is another decision, my lord, of Justice Bhattacharya, Sabasati Bhattacharya, my lord.
Taking a different view.
Yes. There's only one paragraph which has been referred.
That was not cited, but I have that judgment also. I have got that judgment, though that was not formally cited in that matter by either of the parties. But I have that. So that is why now you will be getting two divergent views of two Bhattacharyas.
Judgment also says that court would be the proper court to hear it, but it proceeds on the civil division thereafter. সার্ভিস করেছে এগুলো সব মে মাসের সার্ভিস তো কোথায় তোমরা
কেন জুন কোথায়?
Yes, Mr. Bose.
So my lord, can we come back?
May? But they were supposed to, they said, somebody called and said they are serving last week. I said, go to the bank. Where is the service last week? You have to call in.
Last week, why?
Ask.
Order
They
was
had-
passed long time
They
back.
had
No,
called
no.
in last week.
No,
and they
that
said
is
that
wrong.
they would serve.
My lord, can we come back anytime next Thursday, subject to your lordship? Only on this point of maintainability. There are. কবে করো? ওই বলো।
তুমি বলো
12th.
12th
Can we come back?
Or you can do one thing, Mr. Bose,
My-
because these are the points, both of you can prepare a notes.
My
I
lord.
think that will be better.
I will do that. I'll do. We'll come back with the note.
Because these are the points, this is the only point of law unit, not on facts. Notes is basically on compilation of those judgments which you have seen. And some of the judgment, I think these will be the common judgments which you can, because this is the thing, even if I accept your submission that interlocutory, that distinction, the problem will be, might be that different courts, so very many interlocutory orders challenged before different courts. Final order before another court. Can the jurisdiction vary in this way? Depending on the nature of the order.
Correct. That is also the point. It requires
And
consideration.
final.
No, it requires consideration.
So it has to be fixed somewhere. This way or that way.
Right.
This cannot happen because, you know, because decisions of one court may have persuasive value, may not have any binding precedent.
My lord.
Because I tell you, let us consider an interlocutory order is being challenged before this court. So decision of this court with regard to that issue will be binding. May not be a decision of the Telangana High Court, may have a persuasive value. But if that particular interlocutory order is being moved before Telangana High Court, then it might be in other side's favor, that decision will go.
The basic example is section 17 of the Securitization Act. Here, my lord, Bhattacharya's judgment was there that it is like a suit. So if it is not within time, you cannot ask for extension by section 5. Well, Telangana is held separate. They have said you can apply under section
Yes,
5. So when those matters come to DRAT, he allows. Whereas if we go from court,
yes, that is why. So it will have a very impact.
It would.
So,
It would. It
so
would.
court has to be fixed. Otherwise, everywhere, maybe in one way. Yes.
to the judgments.
No, more than shopping, there will be conflict.
Yes, may not be forum shopping because may not be forum shopping because depending on the if it is held, it has to be on the basis of the appellate tribunal's order. So whatever there is, may not be a forum shopping, but it's a conflict of
right. Understood.
12th, my lord.
12th.
So you can work out on this
Understood.
aspect
We'll work
also.
out and come back.
The
to
other is more or less the judgments have been cited, but this issue requires some consideration.
Very well. We'll try and look up, my lord. We'll also hunt for some more in
Yes,
case we get
you hunt
other
for
courts.
some more
Anything.
because please do it early because
We'll dig it up.
otherwise that I have reserved it and I was minded to deliver it very soon.
Your lordship needs to postpone that by a few weeks.
That's the difficulty because it has been adjourned because that is also on section 5.
Oh.
That's also on section 5.
So then your lordship gives us on the 12th. We'll come back with the note on the 12th and both.
That is why I'm requesting both of you. I'm making a departure. I do not request
back with
the
the note.
parties to bring the written notes on the very first day.
Very well.
But in this, since this is the legal issue involved, please come so that it can be.
12th. 12th.
12th আছে ফাঁকা আছে
ঠিক আছে great. Yeah, he's fixing.
By the order impugned, the application under section 5 of the Limitation Act, praying for condonation of delay in preferring an appeal before the date
1448. Item number 459.
Not today.
Let answer the petition.
You are appearing. First time.
First time.
No caveat.
Caveat nahi to? I've been told no caveat, but I just checked it. একবার দেখে
দিন।
দেখে নেবো আজকের দিনটা এমন দিন।
Yes.
Referral number 2 is the petitioner before your lordship. Very interesting shoot, my lord, page 11 of my lord's brief.
Suit is disposed of.
No, my lord.
Yes. Which
But-
order you are challenging?
My lord, that is my lord 711 order, my lord. I am challenging the order number 29 dated 16th of December 2024. My lord, the first bunch of the
2024.
yes, first bunch of the certified copy, my lord. Its entirety of the order sheet is being
No, after that suit dismissed. I've seen the last order is suit dismissed. 13th of September 2022.
that is maintainability application.
But suit was dismissed. Suit was restored thereafter.
Huh? Yes, it
That's
must have
suit
been
number 815 of
because my
2020, 13th of September 2022, it was dismissed on contest.
no, thereafter, my lord, it has to be, my lord, restored because
No, you are the counterclaimant.
yes, so my counterclaim is going on. Yes, my lord, I have stated.
Yes, yes.
Counterclaim is going on. That's for a long time, my lord, today the matter has come up. But the defendant number 2 is the petitioner before your lordship. The plaint case was that he has arrayed, my lord, the defendant number 1, the bank as a party, wherein, my lord, the plaintiff's account was declared to be NPA. So ultimately, bank came and filed 711 application allowed. My counterclaim is that in respect of the suit flat, wherein the relief is being claimed by the plaintiff, because there is a deed executed, the bank paid the money, the loan amount. But apart from bank, the earnest money, which
Who are you?
well, I am the developer.
Yes.
I am the developer.
Bank paid it to you.
Bank paid the amount of money which has been applied under loan. Your lordship knows the entirety of the consideration amount may not be obtained by way of
Your claim is with regard to the balance.
balance amount which shown in the deed to be handed over by a check. I say that checks were not being handed over, 2 checks. So that is my claim in respect of my counterclaim. What is the suit flat? They have
So what happened? What is the impugned order?
By virtue of the impugned order, a third party who is a owner in respect of a different flat of the same building, he proposed to add as a party in my counterclaim, and that application has been allowed. The learned trial judge says whether the suit flats are tallying or not, that is the subject matter of the trial of the suit. That is the order impugned before your lordship. But I shall show only 2 pages before your lordship. The 2 schedule of the impugned deeds. Not impugned, first is at page 68 it start, but the schedule your lordship will find at page 78.
Give me a minute.
It's all right. That's right. 3 page. Impugned order, my lord, page 5, your lordship takes up from the last
I am at
paragraph.
page 5, last paragraph.
Last paragraph. That will suffice.
You are the defendant number 2.
I am the defendant number 2. Counter claimant. Flat number, area of flat, the measurement thereof, the site, everything is different.
Show me the application.
The
Show me the your counterclaim.
my counterclaim. But my counterclaim, it's it starts with page 21. Your lordship will get the prayer at page 31. And schedule also 32.
Where is the application?
Yes, application is at page 101, my lord.
Where is the plat number of
Yes,
the...
my lord, plat number, my lord, has got, my lord, the schedule of my counter.
Yes, your flat number is 280 square feet.
Kindly tally it to page 78.
And in the second floor.
Yes.
And with
my lord, page 107.
Why
The applicants, my lord, did.
Oh, he has not stated that in the application.
Even not.
10.
We have stated, my lord, in our objection. 116, my lord, is the, my lord, schedule.
So you are the developer. So
No, my lord, this is a separate flat. This is a flat owner of a separate flat, not connected with this. This is flat number 206. Build up area is 850. Site is, my lord, southeastern side. And, my lord, the deed also, my lord, I have annexed. My lord, the subject, my lord, suit. That is page 78. Entirely different. This cannot be relegated, my lord, at the time of trial.
the
567. 567.
567. Yes. Not today. Go to the daily fix that one.
1364.
The 1364 to take it. I'm allowing that, Mr.
Lord, I am. Lord, I am not claiming any equity. Kindly says.
What is the suit for?
Suit for declaration and injunction.
Saying that they are taking step or taking construction over to the approaching some option. They have taking step for construction of a chala. That is my opinion.
Of a chala.
Yes. But they have they have to dig up the soil.
So this is not a suit for partition.
No.
For declaration. And they admittedly they have no document that they are in possession. Record of rights are in our possession.
No,
At the time of
Lord, RS record is in my favor.
All right, let him, because it's his application, let him start.
Partition should generally matter, but it should be permitted to make some. Not that.
But even in declaratory suit, if I am out of possession from the very beginning, my construction is there. That is admitted in the local inspection report.
364. 364.
1364. But that was rejected only on the ground that there is a status quo order.
There is
one order of status quo, order of injunction.
If there is an order of status quo, that has to be, unless that is modified, how can that be, how that can be allowed? File an application for modification of that. I will permit you to file an application for that. Because more so, if there is an order of status quo, how that can be, and if you say, yes, my prayer for modification was rejected, then it's an appellable order. Choice is yours. I can give you liberty to apply for, prayer was there for modification? No.
No, not modification. Kindly.
If there is no prayer for modification, they can order.
Kindly turns to page 45 once.
45, yes.
Lord, I know.
There is a split AC. Oh no, this is the meter board. Electric meter, page 49, that photograph.
Yes. Oh. Electric meter is there.
Page 45.
45, my prayer.
Yes.
ইনডেসিমেল সম্পত্তির মধ্যে অধীন বিবাদীর মাটির দেওয়াল ও খড়ের চালাযুক্ত পুরাতন বসতবাটি
repair করিতে পারে. So permission for repairing.
Only is that.
Show me the local inspection report.
My lord. My lord, kindly turns to.
What do you want to repair? Where is the schedule? চালার উপর পলিথিন দিলে জোর করিয়া খুলিয়া।
টেনে ফেলছে।
So what is the schedule of repairing?
Not schedule of
This
repairing.
is a tea stall. This is a tea stall.
বসতবাটি is a গোয়ালঘর, etc. That is stated.
তো ঘরে চালা রোদ বৃষ্টিতে না। So roof of that.
Only bamboo sticks and below the chala.
Mato, why are you? Show me the local inspection report.
Kindly turns to the report. Page 40. 41 is the relevant portion, Milord.
Yes.
পূর্বাংশে 3 ডেসিমেল সম্পত্তি যেখানে ঘরগুলি রহিয়াছে তাহা বিবাদীর দখলে রহিয়াছে।
No, this cannot be a repairing. It has to be a reconstruction.
No structure.
No, it cannot be repaired. Everything, commissioner's report is against you. There is no wall on one side. Everything has been demolished.
He has not
If you
allowed.
want, I can give you liberty to file an application for
He has
modification.
not allowed us to repair, my lord. That is the.
This is repairing cannot be done. It's reconstruction, sir, now. If you want to reconstruct,
My lord.
you have to pay for modification of the status quo order.
I will not, my lord, let us at least, my lord, put the tarpaulin over there.
Cannot be done. Please
In
see.
presence of Mr. Mahato or any other advocate.
So that if you can impress upon Mr. Mahato, if he agrees, it's a different thing altogether. But page 41, commissioner's report, there is no existence of the room now. ছাউনির ঘর পচিয়া গলিয়া পড়িয়াছে।
Naturally, my lord, and
this is a
straw thatched house cannot survive in the rain.
Yes, yes. So, and this is a report of November 2023, almost 2 years now. So it's further damaged.
He has not allowed us to repair.
I appreciate that. But if you want to reconstruct, you file an application because repairing is not possible. From the report itself. What is the finding of the learned trial judge?
Kindly cease. After page 51, minute. May I just place the last paragraph of the. It seems that for the protection of the suit property till the disposal of the suit, such injunction order was passed. There is no claim made by the defendant that such order has been challenged.
No, you have claimed that you are getting that government fund, Sarkari Awas Yojana. Sarkari Awas Yojana is for construction, not for repairing. This shows more so that you want to construct afresh.
That I am not.
That is a pakka construction.
That has been rejected. Once the inspection was made, since it was not allowed, that part has gone. Now,
finding is correct. Referral of the does not help the present cause.
That is why.
If you want, I can give you liberty because unless that status quo order is modified, you cannot do. Or
let us at least put the tarpaulin over the.
You cannot.
Bamboo sticks.
There is nothing you cannot put.
Kindly appoint one advocate commissioner so that he can go and under.
If you want, I can give you liberty to file an appropriate application for reconstruction or for whatever it might be. Because for that you have to apply for vacating that status quo order. Status quo order is there. You have to take up.
Initially, the order of injunction was passed ex parte. Thereafter, the objection was filed.
Now there is an order of status quo. So what was the status quo? What was the status? I cannot decide from here.
Existence of any structure has been denied. Very much pleading
And
is there in the case.
my pleading is this: property has been recorded in my name.
Sir,
since 50
you are relying upon the commissioners. You are relying upon the commissioners report. There has to be some basis. You are relying on the commissioners report. On the basis of the commissioners report, repairing cannot be permitted. This application under Article 227 of That is why I have said it is not a case of reconstruction, repairing I have rejected.
Kindly add one line, otherwise we not.
It will be open to the petitioner hearing to. Yes.
My lord, Passover matter, item number 10, only for extension, it's there.
Where is your other side?
Today it's expiring, my lord.
Cannot be helped, sir. Today there is a resolution.
Matter, my lord, no KVA. Today's matter, my lord, 1433, right?
1433.
Today.
Today's item number 1433.
And no
Combined list. It was called on.
No KVA, my lord, let it be taken up on a 2K, my lord.
Where were you when it was called on?
On date in another footnote. That's the problem.
What is the matter? There is no caveat. What is the impugned order?
Impugned order, my lord, I have filed an application for stay the execution procedure. That application, interim order has been.
Come at 2 p.m. ওটা 1433
Lordship, item number 17 of today's list, Lordship.
1717.
17.
Yes.
If your Lordships kindly takes up this matter after
17.
17.
Whom heading? Order has been passed. Key order. Yes, yes. It has been adjourned for the order has been passed.
Pension আমার list আছে।
Before your lordship takes up the matters, your lordship, item number 8 was passed over in the morning. It is for extension of my interim order, your lordship.
Where is your other side?
Other side is not there, but the interim order expires today, your lordship.
They cannot be taken up. Maybe the other side is there.
If
Yes.
your lordship extends it for 1 week, I'll give notice and come back.
Let me see, tomorrow it will be taken up.
Yes.
For 1433.
In this matter, my lord, I'm for the petitioner defendant.
Yes.
My lord, the order, my lord, that order has been passed. Suit has been decreed against me. I prepared title appeal. Title appeal order passed in favor of me. Thereafter, they prepared a second appeal. Second appeal order in favor of the plaintiffs. Thereafter, my lord, I filed review application, and in lower court, my lord, they have already started the execution proceedings by filing order 21 rule 97. That is pending on 14th August.
What do you want now?
No, my lord, I want to, my lord, stay the review application till the hearing of the review application pending in Seattle court, till the disposal of this application, my lord. This order 21 rule 97, that execution proceeding rule 6 order.
What is the impugned order? Please come to the impugned order.
Lordship space.
What is the impugned order? What is the
That
date
is-
of the impugned order?
That has been given, my lord, in page 13, my lord.
What is the date?
That is the 17/4/25.
Give me a minute. No, what is the miscase for?
That is miscase for execution proceedings, my lord.
No, no, miscase is not for execution proceeding. Miscase is section 47.
Section 47, my lord.
Yes, so section 47, what has been done?
That is pending. That has not been taken. They have already taken, my lord, order miscase 31. That is the lordship.
Yes, miscase 31 is for section 47.
Yes, my lord. They have, but
Why are you paying for stay?
I'm paying for that, my lord, order. Police had they have already started police. Before hearing that, before hearing 47, my lord, I want to take that matter by state that execution proceedings 6 of 25. That has been pair in the pair matter I have stated. Stay all further
No,
proceedings.
no, why it will be stayed?
Yes.
Why it will be stayed? Your miscase was fixed on 7th of June. What happened on 7th of June?
7th June, my lord, they have already directed the copy be served to the other side.
Yes, no. That direction was on 17th of April. So did you serve copy or you have not served
Already
copy?
served.
So what happened on 7th of June?
7th, my lord, they have already prepared this matter on 14th June, 14th August.
Yes, copy has been served.
No keep
No, not here.
That
There.
copy served. That copy has been served.
What is your ground in 47?
But my lord, issues are not properly adjudicated.
That cannot be accounted.
No, my lord. Evidence of the plaintiff, his evidence was not taken. That's my lord. Yeah, I'm praying, my lord, let this matter be stayed, my lord, till the disposal of the order. That's second.
No stay.
No, my lord, petition will be evicted, my lord, by the police, my lord.
Has to be. Up to second appeal, it has been, degree has been confirmed, execution has to proceed.
Review application filed in the High Court. That is pending.
Obtain a stay there. Move the review application, obtain a stay there. If High Court review is pending, obtain a stay there. This application under Article 227 of the Constitution of India is at the
daily list fixed matter. Item number 84. Item number 130. 84.
No, 130, yes. Ex parte or other side is there, Mr. Mitra.
Other side, we have served. I know.
Dude.
I'm not on that. Not on that. My lord, I shall give your lordship, my lord, very briefly the background. And my lord, I shall pray for my lord fixing any day, my lord.
Yes, what is this matter?
I'll tell your lordship.
Who is your other side?
Let me just say.
Who is your other side?
I'll tell you. Amit Nag Aquila. I shall again, sir. I will tell your lordship.
Yes, what is this?
My lord, a property was leased out, a long lease, my lord, for 9 years, a registered document. Property on VIP Road, measuring, my lord, an area of 43,123 square feet. It was leased out in 2009.
You are for the opposite party. You are assisting. Yes.
The monthly rent, my lord, admittedly, or at that point of time was, my lord, 26,50,000. In
Monthly rent?
Yes, 43,000 and odd square feet. With, my lord, 40 carpet.
What is the impugned order?
I will give you a lordship. When, my lord, the COVID, my lord, came into the COVID, my lord, pandemic, my lord, hit. Now, my lord, thereafter they gave a letter that we cannot pay the rent. We shall pay rent at the rate of 2% of our monthly sale. My client refused. Even thereafter, they did not pay. They continued to take that stand that we are not liable to pay rent. Ultimately, my lord, a notice was given that was in September 2020, that either if you clear your outstanding dues by this date, or else 2 months thereafter your tenancy shall stand terminated. No payment was made. From, my lord, April 2020, my client has not received a single paise from the property. Now, suit was filed. So after filing of the suit, since it is a commercial dispute, my lord, an application was made under, my lord, Order 13A, which has been, my lord, incorporated. The learned judge dismissed my application by saying that whether the notice is a valid notice has to be determined. Now, my lord, for that no evidence is required. The notice will speak for itself. The learned judge says whether a composite notice can be given, that has to be considered. Now, my lord, as on date, my lord, my client is not receiving a single farthing for 5 years. And, my lord, no. Now, this is, my lord, the background.
Where is the plaint? Have you annexed the plaint?
Yes. It is at page 35. 35. It's a shopping complex, man. They are merely carrying on business therefrom and depriving me.
So your claim is occupation charges during pendency of the suit.
And mean profit. It's a lease. Lease was terminated. It's a lease governed by the provisions of the Transfer of Property Act. It was terminated. And, my lord, thereafter the suit was filed. My suit is for recovery of, my lord, possession as well as, my lord, for.
So according to you, since the lease has been terminated, you are entitled to mean profit with effect from the date of termination of the lease itself.
Outstanding rent in between. From April 2020 till, my lord, November.
So you are claiming mean profits at the current market rent, not the contractual rate.
They are not even paying that, my lord. For 5 years, from 2020, my lord, the Supreme Court, I shall place before your lordship, Supreme Court says that people let out property to get, my lord, some income. I know this is a company. Again, my lord, the companies also require income.
So this has to be because the uh, rental has to be, so it cannot be a Premises Tenancy Act suit. It has to be a Transfer of Property Act suit. Maybe under the rent control legislation, there are some protections, occupation charges may not be. But if it is under the Transfer of Property Act with regard to the expiry of lease, or you can say the termination of the on the ground of breach of the terms.
We have, my lord, sought for this summary judgment on the admitted amount, not on, my lord, the in profit portion. My lord, if your lordship is pleased to come to my application, my lord, which starts at page 54. And the prayers are, my lord, at page 62.
Summary judgment on account of this, whether can be passed.
I will show you, lordship, my lord.
Because
this is akin to, my lord, original side, chapter 39.
Yes.
Now, my lord, if there is no defense, my lord, the court can pass up, my lord. There are a number of these.
Yes.
That
No, I was only because till how long, that is what I am saying. Quantum will be fixed, but till delivery of possession. Has to be till delivery of possession because your suit is for recovery of possession.
My lord, today I shall, my lord, I shall take instruction, but at least, my lord, the money should come.
Yes, because the earlier view was that once the suit is pending, you are not
That has
entitled.
changed.
You are not entitled to. Maybe that you are entitled to mean profits with effect from the date of termination or efflux, whatever it might be. But after the decree is passed.
That is.
So there are some decisions now, also a division bench decision of our court also. But I've considered that in a rent control legislation, I have made a departure from that because under the rent control legislation, this principle may not apply. So I've considered those line of decisions in the light of that provision.
Now, my lord, kindly fix any day, my lord. I cannot take, this is the time I would take on that day also. At best, I would show, my lord, some documents, the lease deed.
Notice in course of this day.
Yes.
Tomorrow. I'm keeping it for tomorrow. Time will be, I will fix it subsequently, but you can indicate in the list that tomorrow.
Item number 155. Item number 155.
Lord, I appear for the petition. Yesterday, my lord took up this matter and my lord, on my request, my lord kept it for today.
There is no other side, no, there is other side.
Yes, my lord,
Mr. Chakraborty, there is other side, there is no other side.
there is other side. He appeared, prayed for a copy.
But Mr. Chakraborty, what can be
Should
done?
come back tomorrow. Wait a second. Yes. But I tell you also what happened, my lord, the father is the petitioner before your lordship, my lord. I was given 3 dates, then my lord may look into the order impugned. On 12th of September, the trial court granted visitation in the house of the mother. 12th September 2022, trial court granted visitation in the house of the mother, Lord, for Lord, every fortnight on Sunday for 5 hours. 15 June 2023, I filed an application for change of venue because I was facing some discomfort in my in-laws house. Lord, on 14th of March 2024, filed an application for modification of the order dated 12th September 22. 3 dates I have given: 12th September 22, first order; 15th June, I paid for change of venue; 15th June 23, 14th March 24, I filed an application for the modification of the original order.
Yes, then what was done?
But then on, just give me a second. Yes, not on, on 26 June 2024, court fixed both the application together.
26 June.
June 20, by order date 26 June 2024, court fixed both the application together, but not ultimately would write the impugned order. Court has allowed wife's application, did not even consider my application, and kindly now come to the impugned order.
11th of November.
Yes. Today is fixed for, I can take your lordship to all the orders which I have given reference. Today is fixed for order in respect to the application filed by the respondent mother dated 14th March 24, wherein she has paid for modification of the order dated 12 September 22, by which petitioner's prayer for visitation right was allowed. Petitioner in instant application stated that the minor child who stands attention deficit hyperactive disorder. But I think still I am suffer with that. ADHD stands for hyperactivity disorder.
Yes.
But I think still I suffer from that disorder, my lord. Hyperactivity disorder, if this is the disease, mother shows this is a disease. Patient and became patient and restless. When the petitioner met the child at Money Square Mall on 18th February 2024, the child was not inclined to meet and spend time with the father, and the petitioner also became excited and used filthy language.
Is the mother?
Petitioner is the father.
Father, yes, yes.
And used filthy language, and she has stated that in her application that this child.
She has stated in her application, it has to be the mother.
I think she meant the father got excited. I think she meant the father got excited. She would not say that she got excited and used filthy language herself. She would not say that.
Also become and she has stated in her.
But I'm reading it again.
All right, all right.
Yes.
So according to you, the father got excited.
According to them, father got excited. Incident in negative improvement of child which has been achieved due to prolonged treatment, and the responding mother has therefore paid for money to child at barak would be safe and convenient. The father filed written notes of argument along with several document decisions, gist of which the parents cannot be the guest in the life of a child, and the father has got unfettered right of so and so. It appeared that on 26 June 2024, an order was passed by this court wherein it was reflected that the child has made significant improvement on account of treatment, and the petitioner's prayer for further inquiry to the health of the child in the government hospital. That was father's request, but they are no doubt that the relationship between the petitioner's father and the respondent mother is not at all cordial, and it would serve the aims of justice if the meeting between the petitioner's father and the child takes place twice in a month, the first Saturday.
The 12th September, it was fortnight every Sunday of every fortnight. Twice in a month, 5 hours. That was the 12th September order.
Yes.
The court modified that meeting between the petitioning child take place twice a month, between being first Saturday and third Saturday of every month in the courtroom. Courtroom from 3 p.m. to 5 p.m. Time is also shortened. The other portion of the order relating to making video calls shall remain unfettered. The petitioner right to meet the child during vacation, as mentioned in the order dated, shall also remain unfettered. The respondent shall continue to inform the petitioner the school
Where the
activities-
parties are residing. No, where the child is residing, not the party.
Child is residing with the mother.
Where?
This is the address. It is in Boranagor.
Boranagor.
Lord, I
You
tell you,
reside?
I am staying in Bangalore. I come to meet the child.
You stay at Bangalore. So you come every fortnight.
I used to come every fortnight for the child only.
All right. So and the meeting place previously was at Money Square.
Not what happened. I think the parties have agreed for a mall visitation. That was during the vacation. If Milo takes up the 12th September order once, kindly come to page 34 of the civil division.
So there is no other mall near the house of the.
There are 2-3 things. She stays in Boranagor. There is one mall in near Nager Bazaar. That is Diamond Plaza Mall. That's and Salt Lake City Center would be the best, I think. Salt Lake City Center would be the best. I can also space. There is some play activity in Salt Lake City Center. The child is about 8 years old. He was born on 13th January 2017. Not court, firstly, is not a happy place. Secondly,
8 years old.
13 January 2017. So that means 8 year and few months. 8.5 year old.
Yes.
So 2 things I tell you, Lord, in City Center 2. If it is City Center 2, there is a place called Simba where I also take my daughter. Lord, now those practice of going to a field and play, that is gone. Now everything in a mall, there are play zones. So there's a play zone in City Center 2. So he can also play and get some activity done. There are good restaurants. They cannot City Center 1. Any of the malls, I believe, Lord, would be all right. And this time, it should be 5 hours. It was originally every Sunday or twice in a month. If I come from Bangalore.
When did you last meet your child? Son or daughter?
Son.
Son. When did you meet your son?
Lord, last I believe, Lord, after the order, Lord, once I came to court, my learned friend will correct me if I'm wrong, Lord. My advocate on record is not here. Exact instruction I cannot give you, Lord. I'm sorry. But
prior to this, as per the earlier order,
yes, see the important problem happened on one day. Then he said that it is not. I'm not able to see my son.
Prior to that, it was happening.
Yes, during vacation, it happened in Money Square during vacation only. I will show the portion of the order.
Sir Chakraborty, the initial order which you are saying at Money Square was in September 2022.
So when order of come kindly come to page 38 ordering portion.
Page 34.
38. Basically got that order.
Page 34, yes.
38. Yeah, looks like original. Our Mangla see asking.
Oh, this was at the mother's residence.
Yes, initially mother's residence.
Then
can you read the next portion? In vacation, 39. In vacation, vacation permitted to meet the son once in 7 days, and their meeting shall be fixed by mutual agreement. In the vacation, the petitioner can take his son to park shopping mall.
So then it was
the vacation time when he took him to Money Square Mall.
As per mutual agreement.
Otherwise, it was her residence. For my application, that was not touched by the court.
What is your application?
Yes, I'll show you, Lordship. Yes, madam, takes me page 40. Madam, can you got that page 40?
Yes.
So, humble petition father, that not page 47. Kindly come to page 47. This is filed prior in time. Venue of the visitation be shifted to the house of the petitioner father in Kolkata, and the total visitation will be increased at least 8 days in a month, such that the child can enjoy unsupervised physical visitation. This is not been passed by the court. So this is neither allowed nor rejected on Saturday and Sunday with the
No, this application is pending, disposed of.
Filed better and allowed.
All right. So this application has not been touched.
And can we take
Yes,
one?
yes, let me.
One more page of the petition. Can you take the page 76?
Yes.
This is 26. See the top left hand side.
Yes.
Can you come to the next page?
What is 26 June?
26 June 2024, court has passed some order. I am showing the relevant portion. Can they come to 77 ordering portion?
Yes.
On 20th July, application filed by the respondent mother regarding the order of 12 September. Court fixed both the applications.
But only one application, the other is still pending.
Still pending. My lord may direct the court to hear my application on merit, and my lord, in such time, we should not visit a mall. And 5 hours that was fixed. Instead of mother's house and court, my lord.
Yes.
Character problem, there is one more problem. Every day, there's a resolution. If there's a resolution, in trial court, if there is a from 10:30 nothing happens. So if there's a resolution, there's no court, there's no officer in the court, so there's no visitation also. And when there's a court, in court, thousands of people are there, very uncomfortable.
Yes, yes, sir. Please adjust the microphone. Yes. Yes.
On. Now it's on. My lord, that particular child is not a normal child. So the condition of the child must be taken care of first. The child is an ADHD patient. What is ADHD patient and what is the nature of that particular ADHD patient is very much relevant in this case. And basis of that particular terms of that some conditions of the medical treatment of this special kind of children has to be looked into at the time of visitation. Otherwise, there will be every possibility the child will become more ill because it's a mental problem. What is ADHD, my lord? As per the International Classification of Disease for Mortality, in page, it's an 3,000 pages book. I only just Xerox copy of the CD 11 page.
Only one thing.
Yes.
Before going into that, presently, the court allowed visitation in a court premises.
And why? Why?
For, no. In a court premises for 2 hours. You are not aggrieved by that. You are not aggrieved by that till date. So now, court may not be a very congenial place for a visitation. So instead of court, what should be according to you the other alternative place? Because court for the visitation may not be an ideal place for visitation.
Kindly
Suggest, I'm asking you, suggest a neutral venue. So, and if you want some protection, that I will consider. Court is not a congenial place.
My lord, as
in
my lord,
courtroom on to this.
I'm coming to this point, my lord. Just allow me for just 3 minutes time. I will not take too much time of my lord. 3 to 4 minutes time. My lord, my client is never against the visitation right of the father. It is written in the petition each and every places. This is not the first time the visitation right has been allowed and the court places, that means the court premises has been fixed for visitation. There are so many events before that. First, it was fixed at Eco Park, considering that it's a park area and opposite there is a Mishti House and all this. So it will be a beautiful place. There, the father and his relatives, who are the in-laws of my client, they created problems. And after that, it was reported to the court. Change the place immediately. After changing that place, it was fixed at Mani Square. In Mani Square, again, the father created a problem. The problem lies elsewhere, my lord. Actually, how much the father, that means the petitioner, is really interested to meet. What is the purpose of visitations? The father wants to meet. And the relations between the child and the father, whatever the problem may be within the father and the mother, the child should not be deprived. That is the purpose of visitation as per my understanding is concerned. So visitation, if the father mishandled the minor child, if he beated the minor child for a little bit of issue, in a case of a normal child, it's not a problem. But in a case of HDFG patient, it matters very seriously. It has to be considered very seriously. After considering those points, court thereafter fixed the court premises for the safety of the child. In front of the court, court said, I will sit in the court premises, in my courtroom, you please meet and do all these things. The father, I will show you, show my lord, the father doesn't know about the choice of the child. The father doesn't know, doesn't care what the choice should be suitable for the ADHD patient. He doesn't know. He never participated. Actually, what is needed? Visitation rights. Over that, the need is in the time of the therapy counseling program where the parents should be present for the improvement of the mental condition of the child. There, never the father attended. For the excuse already I heard from my learned friend that I am studying at Bengal.
You, only one thing, the child requires frequent medical treatment.
The child
is attending therapy.
Is under therapy, number one.
Monthly basis or
no, there is a stopgap within the one treatment date to another treatment date.
What is the next date of treatment?
The next date of treatment in this month. In this month, if I
when?
That means in the month of as per the instruction as I got from my client, it's in the next week, in the second week of the August. But
second week of August.
Second week of August.
Only one thing, Mr. Chakraborty, can your client attend at the therapy?
Yes,
on that day?
I will ask them.
Never attended, my lord. It is reported in court, my lord.
You have to assure this court that your client will attend that clinic or whatever it might be on the next date.
Yes.
Take instructions.
This is needed,
ask your advocate on record to take instructions. What is the next date fixed in the therapy?
My lord, I will take the instructions.
And you also ask your advocate on record to communicate with your client.
My lord.
He has to be present in the therapy on the next date.
It's his son. He should. It's his son. He should be present.
Yes.
So
he never attended. He never attended. It is reported in the media. I can show my lord. Yes, my lord.
Let him make
That
the
will
other
be taken
argument.
care of.
My lord.
That will be taken care
The
of.
next point. I have not against what my lord thinks fit about the places of to meet with
I'm
the
asking
child.
you. I'm asking you what is the except apart from court, what should be the ideal place according to you?
My lord, I'm coming to
your.
I'm taking
near to your residence.
My lord, I prayed for 2 minutes time for that. I'm coming to that point, my lord. Attention deficit hyperactivity disorder. That is the full form of HDH, ADHD. And the definitions, within the definitions, it's an UN report. Within the definition, it is specifically written, hyperactivity refers to excessive motor activity difficulties with the remaining still, most evident in structured situations. It is very much important in this matter. So, actually, this type of patients, means minor patients, should be in structured routine. And that the father without knowing this particular point and without caring, he knows about that. Without caring about the structured routine, he wants to actually break the routine. Why I am telling that? What is the evidence I have? The district court already directed about the video conferencing as he is working in Bangalore. It is already allowed. I have the entire details from the date of order till date, how much time actually in video conferencing the father met with his son. The seconds are 2 seconds, 18 seconds, 3 seconds, just formality.
Yes.
Just to show to the court that I am a very good father, I am very responsible. Actually, the fact is not that. Second point. My lord, there is a petition which was filed before the court regarding the ill behavior of the father, recording that. After that petition filed before the district court, then this order was passed, restricted particularly in court premises. It is absolute right, my lord. Court premises is not the very good place.
Considering you know,
yes,
you are the best person to know what will be the best for the child. That is why I'm asking
protection, my lord. Protection. A place where the child will be protected, number one.
Yes.
Number two, there is another 2 points also.
Section I will consider. What is the best place according to you?
Yes.
Except court.
Where? That particular ADHD patient should feel comfortable.
I'm asking you.
That is the place. That is the place of my place. That is the mother's place. She is in custody of the mother. Number one.
Sir, please, because you are taking to court, it's different from the mother's premises.
I am not. It's a court's order to fix that particular place.
And you are agreeable. You are not agreed by that. So it's an independent place, not the mother's house. So except the mother's house and the court premises,
my lord,
suggest a neutral venue according to you.
My
Best place for this child.
As per my little experience about this visitation is concerned.
Money Square, it was being made.
Money Square or the Eco Park, those are not the suitable place. I think it will be better if it is in the place of any temple like Dakshineshwar temple. Because at least it's a religious place where the father will not do anything,
without making any comment on these religious other things. Sir, a child of 8 years old, a playing zone or a food court or something or park, these are the ideal places. So, I'm not saying anything, I'm not making any comment.
My lord,
so suggest any other. So consider in mind the age of the child.
My lord, it's an 8 years.
That is why.
So playing zone already tried and failed due to the misbehavior of the father.
That will be taken care of.
Due to the misbehavior of the father.
So with the misbehavior,
the child was beaten by the wicked by the wise father.
Sir, I
will report it in the court.
I will protect the child with regard to that. I'm asking you, what should be the ideal place? Please suggest the place. Protection will be the court. So suggest the ideal place.
My lord, the place, any place which is not overcrowded.
I'm asking you, please suggest near to your residence. Please suggest. That is why I'm asking you.
There is a park, my lord.
Yes, where?
It is Bidhan Park. It is Bidhan Park area.
In Salt Lake.
Not in Salt Lake. Where the petitioner is residing, kindly see the address. It's in Bidhan Park area.
Yes.
So there is a park there. I know that particular place. It is very much close to my own house. So it's a Bidhan Park area, which is.
It's a suggestion. Jodi jeta hoy.
Let me finish.
Bidhan Park e giye গরমের মধ্যে বাচ্চার কষ্ট হবে কোনো মলে যাক এসি থাকবে বাচ্চাটা কমফোর্টেবল থাকবে what is the use in doing it
summer and other
যদি এত গরমের মধ্যে পার্কে গিয়ে তুমি আমি থাকতে পারবো দাদা এমনি হয়ে যায় বর্ষাকাল
and other things. Park may not be during monsoon and other times may not be the suitable place.
সিটিজেনরা যাক না কি অসুবিধা হবে
That two things can be provided, but there is something in a covered area.
There is actually the mall places has been already tried. It failed.
Sir, tried. The father has misbehaved. I will protect that.
So city center. City center one will be. I think it will be nearer to the.
What will be convenient, because the not your and not Mr. Chakraborty's flat, but after all, it's the convenience of the child. So that is why I'm requesting both of you.
Options
Please keep in mind the welfare of the child. Suggest the place keeping in mind that, not your own convenience.
No, my lord. Here, our convenience matters nothing.
Yes.
Can I suggest two places subject to my learned friend's convenience? 3 alternate places I'm suggesting. Any of them, let them agree.
Yes.
Eco Park, City Center 1, City Center 2.
He's saying City Center 1.
I said city center.
Same City Center 1.
City center 1 and Salt Lake area. It will be near. Actually 2 and 3 kilometers.
And
from our line.
suggest a special officer.
Yes,
Suggest
my
a
lord,
name
it is
to
very
special
much
officer.
needed. It is very much needed.
That is why I have told you, I will, protection, I will take care of that. Or Mr. Chakravarti, I am leaving, requesting both of
Not
you.
to me, no.
No. Advocate on records of both sides can be the special officers also.
Yes, my lord, that will be better.
আমি
That
বলবো
will be
তোমাকে
better. I'm not.
Why, Mr. Chakravarti, advocate on record, then there will
send
be
one,
question,
send one,
payment and other things.
send one. আচ্ছা সেটা ঠিক কথা।
That is according to you.
ঠিক আছে, he will go.
My lord, advocate
Mr.
on
Bhome will
both
go.
side will be better, I think.
They will present. My
They
lord
will
makes it 4 hours.
If you want an independent special officer, I can also pay for that, but you have to
No,
make payment for
both
that.
side lawyer will be there. 4 hours, we'll have lunch. He will play. I'll see him. The mother will be there. If she wants to come, if she doesn't want to, there will be no interference.
Mr. Chakravarti, mother has to come.
But mother should not come. There should not be interference. That's what I'm saying.
What do you mean by interference?
So
It has to be
the
clear.
special officers, Mr. Chakravarti, the lawyers will be of the both
My
sides will
my
be
lord,
there.
in it,
So, city center 1, any specific zone in city center 1?
Do not mention that.
no, my lord, let it be mentioned, my lord.
Maybe because first floor, I do not know food court in the other floors. I think that can be arranged because the advocates on record.
As per the comfortability of the minor son.
Yes. Everything, advocates on records will be there. And what should be the date? Saturday, Sunday, what should be
Well,
the
only Saturday or Sunday, my lord, because he's in.
Saturday or Sunday? That is what I'm asking.
For him, Sunday is good because he will come from Bangalore for this purpose only.
That you have to accommodate for the, and any routine of the child with regard to tuitions and other things.
Yes, my lord. It should.
Sunday, any tuitions?
My lord, I have to take instructions then, my lord. That
Sunday, you have to adjust. Mr. Chakravarti, will be convenient for your.
In the afternoon session.
Don't make 2 o'clock.
No, from 4 to 8. 4 to 8. Initially, I got 5 minutes. I am giving 1 hour.
My lord, that minor son is an ADHD patient, my lord.
The
He cannot
advocates-
take too long. Interruptions within the meeting has to be given.
But
Otherwise, he will come under depression, my lord.
All right, that will be
Already
given.
depressed
And what is the next?
report, my lord?
What is the next date for that therapy?
My lord, I have to take instructions from the client. my
Lord, one information to my lord.
It is in the second week of August.
One information to my lord.
All right, second week of August, you communicate to Mr. Chakravarti's advocate on record. Mr. Chakravarti.
Just say see page 58. I filed an application in the trial court seeking for that I should be allowed. I am reading the prayer, page 62. Direct alternate medical treatment advice consultation of my lord. Please allow me to say page 50, page 62. Direct alternate medical treatment advice consultation of minor child at a leading government medical institution, hospital like.
Where is being treated now?
Yes.
Institute of Neuroscience, Kolkata.
Very well. Whenever there's a date.
Wait, Neuroscience, Calcutta. My lord, can you see?
In Park Street.
Yes, my lord.
That's a good.
Where he's being treated?
Firstly, the minor son was treated there, my lord.
Now he's being treated.
Now it's an eminent doctor, Dr. Kedar Ranjan Banerjee, my lord. Kindly see, my lord.
I'm going to copy down.
Where is his chamber? CIT Road, Moulali. Mr. Chakravarti, if it is on, because I do not know, on Sundays it may not be possible.
Yes, my lord.
But your client has to come on that day.
I believe if the mother takes the appointment on
that particular date when the doctor.
Mr. Chakravarti, it's very difficult. The doctor's appointment, you have to spare that. That you have to do.
He is so sincere and dedicated and caring.
I'm only saying only one thing. I completely bow down. I'm only saying only one thing. If the mother tries to take an appointment on a Saturday, then I can come on Saturday, have the doctor, have the visitor and go back.
My lord, trying is another thing. Appointment of the doctors.
I can also talk to the doctor.
Because the father will come down from on Sunday. So if it is on Wednesday and Sunday, then consider the.
Yes, absolutely. Why not?
So he say you make a try. If required, may not be this Saturday, maybe another Saturday. If that is possible, I do not also know whether that doctor is available on that Saturdays also.
এইটাই দেখুন কাগজটা দেখলে বুঝতে পারবেন
আগে তো দেখি
না না কোথায় অ্যাড্রেস কবে কবে বসে ওখানে তো লেখা থাকবে
এই আমি দেখছি এখানে
During the trial has to hear out my application.
Sir, Chakraborty, you cannot dictate what order I will pass.
একই কথা আমি
I will be setting aside. Please don't dictate the code what order will be passed.
dictate. No, I'm
Said that I will be setting aside, I will be directing this, I will be
I'm only asking a question to myself whether your lordship is minded to do that. Not only that. Kindly do not take me amiss, Lord. I was only
You have
thinking.
made your submissions, I have heard both of you.
I was only
Let the
requesting
the order.
I was requesting my lord may delay the trial just to hear out my application which is pending. That is the only request I was making.
my client, the improvement of the child is going on. It has been recorded in that particular.
What is going on?
Improvement of the child's condition.
Improvement.
Yes.
Has to be. Has to be. I will direct the father also to cooperate in the improvement of.
If it is not cooperated, my lord, then as my lord,
Father,
as my lord thinks.
all fathers will cooperate. All fathers and mothers
He
will
is not
cooperate.
that type of father.
Has to cooperate.
He is not cooperating.
Has to cooperate.
He 1498 case against him.
Mr.
We have taken-
Chakraborty is there. Mr. Chakraborty, ask your client to cooperate with the
Definitely he will go.
improvement of the child. You have to take care of that.
He filed an application. That was
He-
rejected.
he-
Chakraborty, filing an application on paper, you may say.
As per as I will exercise my authority, whatever little I have, I will request.
You wrote the will, nothing will. Making applications,
That is
making
actually
some
lacking,
things,
man.
some allegations.
That is actually lacking, my lord.
Yes, that I know. Yes, this application under Article 227 of the Constitution of India is at the instance
Junior lawyer only can pray before the court, my lord, can never dictate with the court. Kindly, my lord, don't
You are
say all
dictating the court, Mr. And you are not a junior advocate.
No, no,
Don't
certainly.
place yourself in these.
I take my lord.
Oh, only, I was only
Not be a
saying that.
junior advocate and you are dictating.
Don't take it that way. No, no, কখনোই না. Never,
I take
never.
my lord.
Thank you. Yes, call the next
Item
matter.
number 208.
My application, my lord. My lord, this application is completely non-adversarial in nature, my lord. I just,
First time or no?
my lord, there is the second time.
Then other side is not here.
My lord, there is no other side. There cannot be any other side. It's a non-adversarial proceeding.
Why?
My lord, the will which was filed before the learned court below has been retained after an order.
I'm keeping it, making it not today.
My lord, the difficulty, I'll tell your lordship, my lord, the executor is also very senior in age. He also wants.
Okay. Today there's a resolution, there might be.
My lord,
3 PM matter, will your lordship take up?
Please wait. Yes.
very well.
Next, call the
Item
next
number
matter.
220.
My lord, I believe it will retain its position, my lord, tomorrow.
Yes.
Great.
Item number 220.
Passover next. Alache.
Item number 278.
Passover next.
Item number 320.
You appear for the petitioners.
This is the first time.
First time. No caveat.
No caveat. But application under section 372 of Indian Succession Act for issuance of succession certificate.
Yes.
151 application filed in connection with the said matter, in this case.
Yes.
Now, my lord, the impugned order is my lord, June 5, 2023. Order number 1.
Yes, what do you want? Expeditious hearing.
No. My lord,
That is your
challenge
prayer.
that order.
That is your prayer.
No.
Expeditiously, preferably within a 6 months. That is your prayer. Please kindly come to your prayer at page
We
30.
have not filed any written objection till date. My lord, in such event, the written objection.
No, please kindly come to your prayer at page 13. This is your prayer. Dispose of Miscase 169 of 2023 expeditiously.
Within time bound limit, my lord.
Yes, that is your prayer. You want that. What is the next date fixed?
My lord, 6th of November. My lord, I am
6th of November 2025.
2025.
For what?
My lord, for appearance, yes, sir, and appearance of the.
So service is not complete, sir. How can it be expedited?
My lord, kindly see the first portion. They have also challenged. My lord, kindly see the first portion of the order.
Yes.
Page 13.
Yes.
As to why the ad interim order of injunction that is such and such, which has been extended till such and such, should not be set aside.
But Miscase, how can it be set aside? How can it be direct? Because the service returns has not yet been ready. This application under Article 227 of the Constitution.
4, 5.
My lord, I am for the petitioner, my lord.
Yes.
My lord, the motion stage, it was, my lord, dismissed for default, my lord, on the ground that, well, the learned advocate on record, my lord, on that date could not come to court. My lord, due to his father's dialysis on that date, my lord.
What is the impugned order?
My lord, impugned order, my lord, allowing the application under section 151 of the Code of Civil Procedure for repairing, my lord, in spite of the order of injunction passed by the learned trial court, which was affirmed by the learned appellate court.
Yes.
My lord, despite that, my lord, an order for repairing
damage,
my lord, your lordship,
and other things, which
my
does
lord,
not change the
my
nature.
lord, your lordship, kindly see the application for repairing. My lord, I am just, my lord, drawing attention. My lord.
Yes.
The application for repairing, my lord, that annexed D, page 40. Particulars of repairing has to be mentioned, my lord, in the application. My lord, your lordship, kindly come to page 44. My lord, schedule of repairing work has to be mentioned, my lord. Nothing has been mentioned, my lord. What are the materials required, my lord? That has also been that has been mentioned. My lord, the garb of repairing, my lord, they are making they are making the construction, my lord, without taking permission from.
All right, I am appointing a special officer at your cost. They will see that no change in nature and character. That I will do. You at the cost, I will appoint a special officer who will see that the nature and character will not be changed. That I will ensure that nature and character will not be changed. I will restrain them from.
Well, their application is not in proper form. Well, that has to be made. That has to be. You kindly see, my lord, Annex 44. Schedule of repairing has to be mentioned, my lord.
Yes.
But that has nothing, my lord. This is mandatory, my lord. Schedule of repairing has to be mentioned.
Anything more?
Well, that is my lord, an order of
Yes,
injunction.
noted your submission. That is
An order of injunction has been passed by the learned trial court, not to change the nature and character. And
Mr.
that
Gupta,
was.
I can provide for that. If you pay the special officer cost, I will direct appoint a special officer.
Instruction, my lord. I have to take instruction, my lord. Your lordship,
This application Thank you. Yes, next.
Item number 349.
Passover. You are appearing. First time.
No, my lord, there was a direction for
Even
service,
Mr. Chatterjee, how it can be taken up today?
and then we filed an application as well, my lord.
How can it be taken up today? You have adopted a resolution, Mr. Chatterjee.
May I come back tomorrow in the morning?
Tomorrow, I do not know what will happen.
So tomorrow now, Monday.
Let me see, because
No, I'm hard pressed here. Really hard pressed here.
who is hard pressed?
I am, because my property, I let it out after taking loan,
That's not your problem, Mr. Chatterjee.
my client's problem. Well, we do say it's ours sometimes.
Not today, next. Let me see, Mr. Chatterjee, because all matters have to be.
2nd
the-
August?
2nd August will be coming. Yesterday you said no.
I never said no. Some of my matters, my lord has fixed it on 2nd.
So this list will remain on 2nd of August. Let me see how far I can proceed on 2nd of August. Because 2nd of August, this matter you have not indicated.
No,
If
this
you have
matter-
indicated this matter, that will
So
remain.
it's just, your lordship took it up now, that's why.
Today you have already adopted a resolution, otherwise it could have been taken up. What can be done? If all the matters are clubbed in one day, it's difficult, Mr. Chatterjee.
I bow down, my lord.
Because
So if once it's taken up, my lord, may I pray this before your lordship? Someday, my lord, if I can only
all
move it.
matters which
And-
one side
and
is
now
appearing.
This application, my lord, the thing is that I'm
Let me
saying
see how I can accommodate. Yes, call the next matter.
any day, my lord, if whenever your
Let me
lordship.
see how, because I have to consider this. Yes, call the next
Item number
matter.
4.
Item number?
4.
Take care.
But if not, I will, my lord, mention before your lordship. Because this matter needs, there's a little bit of a problem because the bank is now after my life and I can't get any money out of it.
You have taken loan, Mr. Chatterjee. That is why.
The poor people, my lord, they have to, my lord.
Yes, where is Mr. Parthopratim Roy?
He is Jalpaiguri.
I'm for the opposite party number 4.
You are for the petitioner.
I'm for the petitioner led by
Yes.
Mr. Passovers, Roy Lordship. So two order has been challenged, Lordship, where the added defendant file and WS Lordship after.
Mr. Roy has changed his residence.
No, Lordship, yesterday
He's still staying where he was.
yesterday due to some difficulties, Lordship, he could not return.
I
Lordship.
was thinking that he might have changed his place of residence.
Due to heavy rain, Lordship, yesterday it's not possible.
Yes.
Now, the order has been under challenge, Lordship. Kindly consider it is, Lordship, 15th of January 2024, and Lordship, the last order 29th of April 2024.
Yes.
Now, Lordship, what happened initially? Suit was filed, Lordship, for partition, declaration of 50% title of the Lordship plaintiff, and rest 50% in favor of the defendant number 1 and 2. Now, Lordship, an injunction order was passed not to alienate the property in favor of any other person. During pendency of that injunction, defendant number 1, Lordship, transferred the suit property in favor of
Defendant number 1 transferred the suit.
1 and 2 transferred their 50% to Lordship, defendant number 3 to 6. Now
1 and 2 transferred to 3 to 6.
3 to 6.
Yes.
Now, Lordship, 3 to 6 filed their written statement, and Lordship, PW1 was, Lordship, cross was concluded in their, Lordship, 2022. It was fixed for, Lordship, argument. At the stage, Lordship, the defendant number 4 was died. His sister was, Lordship, impleaded.
4 died.
4 died. Now,
sister impleaded.
Sister impleaded. In spite of receiving the summons, within 30 days, he did not file his, Lordship, WS. After several adjournment, he, Lordship, filed his WS and, Lordship, for another application for recalling the ex parte order from the ex parte board. That application, both the application was allowed, Lordship, without giving any reasons, without hearing us. That is the, Lordship, order under challenge of the 15th of January 2024. Your Lordship will find, Lordship, no reasons has been assigned why the WS, Lordship, filed by the defendant number 4 was allowed And what is the reasons behind lordship the submission of the WS after 30 days? Because several adjournment was taken by the without considering that lordship the learned
Yes,
trial court.
Mr. Rai, no reasons have been assigned.
And second order lordship what happened lordship the defendant number 3 to 6 lordship already cross-examined the PW1. It has been concluded in spite of lordship that for delaying the suit lordship since 2006 it is going on. They file an application for lordship cross-examination of the lordship PW1 that has been allowed.
Let him complete, my lord. I will give short reply.
That is order dated 29th of April.
29th of April, lordship. And in a missed case, lordship already.
Yes, Mr. Rai, reasons have been assigned. One line considered allowed.
No, not only that, my lord. Kindly allow me. Cost was imposed.
That has not been accepted.
In view of the facts and circumstances, 2000. That has been complied with. Kindly come to
complied with means he has accepted.
Not, lordship. I have
We have deposited in the court cash.
That is another thing.
So they have to challenge that order also. That has
Which
not
order?
Next order, 13th of March. That has not been challenged.
Mr. Rai, this order is a non-speaking order. No reasons have been assigned. It cannot be allowed in that manner.
My lord, written statement
Yes.
can be filed.
No. At any point of time.
No. After
So-
condonation of delay. After
So
condonation of
where is the
delay.
reason? Nothing. After considering and having regard to the delay, it is allowed. It's not mechanical, Mr. Rai, nowadays. Cannot be mechanical. And the next order also recalling allowed, considered allowed.
Because I have complied with. Then, my lord, my application will be hard.
Yes. This application under Article earned. Can'ta কিসের কেন আবার? What was the
extension of the interim order.
disposed of? Main matter টা চলে গেল, can কি হবে? Disposed of accordingly. Yes, next.
Well, item number 5 is
I'm
that
for the
matter
petition number.
when
That matter.
Custody of the minor.
well, I have had a conversation with my clients. He's also present in court. Well, there was an order for 1 day a month for visitation, right, Malad? Malad,
This is also visitation.
yes, Malad, that person who stays at UAE will come down.
Yes.
Malad,
What is your instruction?
Instruction is twice a month physically and twice a month Malad, virtually.
What is the impugned
Malad,
order?
impugned order is once a month physically.
Only on Sunday, my lord.
Yes.
Only on Sunday. So that is the difficulty, my lord. And additionally, my lord,
Sunday has to be Sunday, twice a month, he says.
Twice a month physically, twice a month
and
virtually.
additionally, my lord, the grandparents, my lord.
No, my lord. Their bylaws lies the
Once in
problem.
a month, my lord.
Their bylaws lies the problem since
Please start with the father, thereafter think of the grandparents. Please start with the father first.
difficulty is the mother who was there. Mother has passed away. She is there with the grandparents and the my lord, the brothers-in-law and
The
the
opposite parties.
yes,
my lord.
yes, yes.
Who is the opposite party?
2020.
My lord, I came to know, my lord, after the death of my wife, my
What
lord.
is the difficulty in the time? If the grandparents also,
He does not even. That is the whole difficulty.
Chaudhary, sometimes
Well, let the father start first. Thereafter,
grandparents has to be start. What's the difficulty if the grandparents also come? Do you have any allegation against the grandparents?
the
There's no
issue
allegation.
no, the issue that had cropped up between the two spouses were with regard to the families. Now,
Mr. Chaudhary,
my lord,
I accept your submission that the grandparents did not earlier meet, but after all, someday it is to start.
Yes.
So you do not have any objection against the grandparents, paternal grandparents. You do not have any objection against that. So why are you
no, my
not
lord.
allowing
What I
them
am
to
what I am humbly submitting before your lordship is that with regard to the father, he is the applicant and he has made their application, my lord.
Father will go. That is I am recording.
Yes.
Why not the grandparents also?
My lord,
What is the real? What is the difficulty?
may I take the instructions? He's there in court, my lord.
Take instructions.
Because of there are as per my instructions, my lord, they have created the ruckus, my lord. The absolute short-tempered person comes over, and that is the whole difficulty.
Who is the
My lord,
short-tempered
the grandparents, my lord.
Both
The
or
fa-
one of
the
them.
father.
So allow grandmother first. You don't have any objection
My
against
lord,
the
that's not
grandmother?
the subject matter in under, my lord, section 7 and section 12, my lord, of the application.
Please wait.
He has not even prayed for the grandparents in the applications.
My lord, what bars him to, my lord, to attain, my lord,
Show
the
your prayer.
Yes,
my
my
lord,
lord.
kindly see, my lord, kindly see, my lord, section, my application, my lord, at
Yes.
page 49, my lord, my prayer.
Yes, page 49. Yes.
My lord, the first prayer, my lord, at page 49, my lord, pass an urgent and immediate order granting interim custody of the minor child, Vani Sonthalia, to the petitioner. Petitioner brings the, my lord, the father, during the pendency of the main suit to the petitioner to prevent.
Only with regard to the father, not the grandparents.
Not the, I have not made, my lord, but there is no allegation vis-a-vis, my lord.
Make an application that will be considered. For the timing, for the father. So 2 days.
2 days physically, 2 days.
Sundays will be.
And Sundays, my lord. Saturday and Sundays.
Why? Saturday.
But I am a citizen of UAE, my lord.
Chaudhary, Saturdays on Sundays, 2 weeks. 2 Saturdays, so consecutive Saturday and Sunday, because he's staying outside. Maybe on some days he may not
Difficulty, my
come.
lord.
So consecutive, so 4 days.
Like it's physically, my lord, as
Second Saturday and Sunday, 4th Saturday and Sunday.
Very well.
Physically and virtually.
Physically, my lord, not 4 days. It was one day was allowed.
Instead of 1 day in a week, since he's traveling.
2 days a week.
Yes,
twice month.
Twice, so for 4 days.
4 days, 4 days includes virtually also,
Actually, what is Mr. Chaudhary? Virtually, how much time?
Why I say this? Why I say this? Why I say this? Why I say this, my lord? May I? Why I say this? The father is an person, all through this time, my lord. Even after the death of the spouse, he is the entire family at large, making several allegations.
Where is the place of visitation now?
Visitation is the place of the grandparents.
So can it be a neutral place?
My lord, that is the whole. My lord, we have no problem. Coming and visiting.
I have the difficulty, my lord. I have the difficulty, my lord.
He is coming. There has been 9 months. He is coming.
Going to the house. I am coming. They are creating problems, but somehow I am already out of the trial court.
What is the problem?
No issue. They are creating impediment.
What is the
obstructions, my lord?
What is the problem?
My lord, I
have you stated that in the application?
No, I have not stated in the application, my lord.
Sir, please don't complicate.
10 months he is coming and visiting.
We have make it a neutral place. Make it a neutral place. I do not have any difficulty, my lord. It's a minor daughter, my lord. They can also come, my lord.
When you file an application, I give you liberty to file an application before the learned trial judge, that will be considered.
The learned trial judge, my lord, what is the difficulty I am facing, my lord? At that time when the application...
So till now you are visiting the wife's place, the maternal grandparents' place. What is the difficulty now?
My lord, I have been told, my lord, they are creating some problem, my lord.
Problem.
The client...
That instruction you do not have. All right. Let it continue. That will be consecutive 2 days.
2 days physically and 2 days virtually.
My lord, don't give it, my lord, virtually.
2 days, Mr. Chaudhary, Saturdays and Sundays.
Yes, 2 days.
Second and fourth Saturdays and Sundays, and 2 days virtually. Virtually nothing will happen. Because after all, Mr. Chaudhary, one thing, 1 day in a week, maybe, so it will be 4 days in a month. Since he's staying outside, I'm making it consecutive 2 days.
Yes, I also joined here, my lord.
So 4 days a month, physically, after all, the father will meet the child.
We do not stand in the way.
Has to go, Mr. Chaudhary.
We are not standing in the way.
That is why, so
My client is also there. He is also not standing.
consecutive, because otherwise 4 days, 1 day in a month will be also troublesome.
What I do, we are not saying 1 day a month.
Sorry, 1 day in a week. That will be problem for him to come.
Saturday, Sunday.
4 days in a month.
It is up to him to come from that place, my lord.
He will be coming. He wants to come. And what is the present video conference arrangement? What is the arrangement?
My lord, any Saturday or Sunday.
What is the age of these? 8. What is the study time? Mr. Chaudhary, please take instructions, study and those.
Yes, I have already taken.
No, with regard to the virtual, don't make it Saturday and Sunday, because Saturday and Sunday he's coming.
No, my lord, I had a talk, my lord, because of her schools and classes.
In the evening, in the evening, after studies, any time.
My lord, post dinner also, my lord, can help.
But before 9 o'clock in any time.
Specific time, 8:30 to 9? 8:30 to 9? That will be convenient.
But twice, my lord, virtually.
Virtually, twice in a week.
Twice in a week.
Specify the days. Except Saturday and Sundays.
Well, virtually once a week, because but to start with, because there are issues.
Which day? Which day?
Well, Wednesday, my lord.
Wednesday. So
8:30 to 9 in the evening.
8:30 to
9 in the evening.
What is the impugned order?
But the impugned order at page 54. Initially, the order was passed, my lord. Later on, it was modified. Or modified not.
Which order is under challenge?
Page 58.
58, my lord. The main order is at page 58.
And this timing, Mr. Chaudhary, this timing is fine. 5 p.m.
Yes. He's coming there.
Physically, we don't
have any problem. We don't have any problem.
5 p.m. How any hours has been mentioned?
No, there was no hour specified.
So as per the, what is the exact, what is the existing arrangement?
But
5 PM till?
But he stays around 45 to 1 hour, 45 minutes to 1 hour.
He stays, he told me, the client told me it stays 2 hours.
2 hours, all right, I'm making it 2 hours, no problem. Or it can be done one thing, 2 hours, so 1 hour, because I'm making Saturdays and
Yes.
Sundays, 1 hour each on Saturday.
He generally stays for 45 to 1 hour.
Very well.
And here virtually is not.
No, it was not even paid for.
It's only physically.
Yes, it was not even paid for. It was your lordship's desire the day before yesterday.
This application under Article 227 of the Constitution
I'm praying for one day approbation for Group Banerjee's illness, Your Lordship.
Item number?
6.
Yes.
One day accommodation
Why?
for Group Banerjee's absent due to illness, Your Lordship. Senior advocate.
What do you say?
Further, since he is asking for accommodation, my lord, I can't say anything, but my lord, this revision petition itself is not maintainable. Challenging the order of DRT, this petition has been filed.
On the prayer of the learned advocate for the petitioner here. Yes.
Yeah, big matter.
And I'm for the opposite party. I'm praying for a day accommodation, my lord.
Why?
Mr. Partha Shastri Rai, Partha Pratim Rai will be appearing in this matter, my lord.
Partha Sharathi Rai.
Partha Pratim Rai.
Partha Pratim Rai.
He is now present in Jalpaiguri Circuit.
He has changed his residence now.
It's that
Let him peacefully stay there.
He was there.
It's that Milord preemption matter where Milord, after the service of summons, I being the preemptee, Milord, there is a suit filed, Milord, wherein Milord, the compromise was added.
Let him make his submission. Let him make his submission, you take note.
Private
Yes.
but he has asked for kindly a day accommodation can be given. A day.
Let him conclude. Mr. Rai will also take some time. Yes. You take notes, yes.
But if your lordship takes up the civil divisional application,
yes. I think factually you had made your submissions on the other day. Now you want to cite decisions. Yes.
Milord, just to remind your lordship, Milord, that initially the preemption application was being filed, Milord, that the non-notified co-sharer and adjoining landowner. That there, Milord, I filed a written objection. If your lordship takes up the written objection, page 22, wherein I specifically mention at the, I may say at the very initial stage when the pleadings in respect of the preemption application was made complete, it was brought to the notice of the preemptor that these things happened.
What things happened?
That is, Milord, paragraph 10, Milord, at page 22 of my lord's brief.
No, I could not follow you.
Milord, preemption application filed.
Yes, what was brought to the notice?
Notice to the preemptor at least that in the meantime, in the interagnum period, there is a proceeding initiated wherein this particular.
How were you informed?
That is, Milord, in my written objection.
Written objection.
Yes.
Yes.
That's why I say, Milord, at the very initial stage, when the pleading in respect of the application for preemption was made complete, it was brought to the notice to the preemptor at least that there was a suit initiated in the interagnum period, and this particular instrument has been declared to be not an out-and-out cell, and Milord, this has been declared by the competent civil court to be a void document.
So after they filed the preemption case, you have filed the written objection stating the fact that
this happened.
Of the compromise decree, you have stated that.
Yes. And Milord, thereafter no steps. What are the possible steps, Milord? I am not here to, Milord.
He has not taken any steps.
Any steps with regard to that. And Milord, ultimately, Milord, the compromise judgment also I have placed page 28 of my lord's brief, wherein it has been declared that the suit and the same is decreed as against the defendant number 1 and the defendant number 2 in terms of solenama petition, and the solenama petition will be treated as a part and parcel of the decree. The solenama petition I have shown before your
that was placed. Yes.
Yes. The বিক্রয় কোবালা দলিলটি ইলিগাল ভয়েড পণশূন্য নট অ্যাক্টেড আপন থাকা ও তাহা আউট এন্ড আউট সেল ডিড না হওয়া এবং তাহা সিকিউরিটি ফর লোন থাকা বাদীগণ স্বীকার করিতেছে। So Milord, this is something that a substitution has been taken place from the place of the preemptees. Milord, whether this can be permissible, Milord, I shall try to, Milord, assist your lordship on that. Prior to, Milord, your lordship's court has now been settled that it is not on the day of filing of the application for preemption you have to show your preferential right, but it has to be on the day of passing of the order also. So in between, whether the substitution can take place, Milord, the preemptee can substitute his right whatsoever in respect of that instrument to any further party during continuation of a suit for preemption, whether that is permissible or not. That is, Milord, the question hinging before your lordship, because it's a case where, Milord, after the notice of preemption is being passed or received by the preemptees, these things happened. Whether that is permissible under the law, that is not. I just remind your lordship that in this juncture backdrop, the learned trial judge will not specifically framed a preliminary issue, not preliminary, other issue, along with the other issues. One of the issues, whether the deed can be the instrument under preemption, can be said to be an instrument which has already declared null and void by a competent court by virtue of a solenama. And since that particular issue has decided in my favor, so ultimately the suit dismissed.
Transfer goes, so the cause of action goes.
Preemption application dismissed. Challenging
So other issues did not be gone into.
Challenging that, an appeal preferred by them. The appellate court found that the court where the compromise has been ad idem between the parties
Did not have the jurisdiction, lacked jurisdiction to pass such compromise decree.
So on that score, ultimately the matter has been remanded. That is the order, my lord, under challenge before your lordship. Now, my lord, may I take your lordship to judgment? That I want to cite this judgment 1958, AIR 1958 Supreme Court, page 838. It's also, my lord, equivalent to 1958 SCC online.
AIR 1958
Supreme Court, page 838.
For what proposition?
My lord,
paragraphs?
My lord, it's not a big judgment, my lord. May I place, my lord, it's some of the paragraph, my lord, I shall.
For what proposition?
My lord, in a preemption application, a similar kind of situation arose. My lord, two preferential right came. My lord, in one application, there is a compromise ad idem. So, right of a preemptee is being substituted with that of a similar right than that of the person who is the appellant, who was the second preemptor in the second application. So there was a initially compromise ad idem in respect of one preemption case, wherein the right of the preemptees is being substituted to that of the second preemptor's application, because both of them are of similarly circumstanced person. So whether this can be permissible, this point has been cropped up in this matter. May I take your lordship to some portion of the factual background that is essential? Paragraph 2, may I place?
Yes.
The material facts are not in dispute and may be briefly stated. The dispute relates to a land measuring such and such, situated at such and such. On 26th August 1949, the defendant number 327 sold the said land to defendant number 1 and 2 for consideration of rupees such and such. On 26th August 1950, the defendant number 8 to 11 instituted a suit being number 231 of 1950. The court of the subordinate judge such and such to preempt the said sale on the ground, amongst other, that they had a right of preemption. On 6th January 1951, the vendees, that is defendant number 1 and 2, and the plaintiffs therein, and the defendant number 8 to 11, entered into a compromise. Under the terms of compromise, the vendees admitted that they had received rupees such and such from the defendant number 8 to 11, and the defendant number 8 to 11 agreed to pay the balance to the consideration amount of rupees such and such on 7th of April 1951. It was further agreed that on payment of such amount, they should get possession through court. As the amount agreed to be paid was in excess of the pecuniary jurisdiction of the court of the subordinate judge, they filed the compromise deed in the court of the district judge, and on the basis of the said compromise, the district judge made the decree dated such and such. It was provided in the decree that the case of defendant number 8 to 11 failed to pay, in case the defendant number 8 to 11 failed to pay the balance to the vendees on April 27, 1951, the suit should stand dismissed, and that if the balance and if the said balance was paid on that day, the vendee should deliver possession of the land in dispute to them. The defendant number 8 to 11 deposited the balance of rupees such and such on 23rd April 1951 and got possession of the land on 17 May 1951. Next, before the said defendant deposited the amount in court, under the terms of the compromise decree, the respondents herein claiming to be the owners of the land in the same party filed suit numbers such and such in the court of the subordinate judge, second class, Farid Court, to enforce the right of preemption. To that suit, original vendors were implicated as defendant number 3 to 7. The vendees as defendant number 1 and the defendant number 8 to 11 contested the suit inter alia on the ground that the plaintiff had no right of preemption superior to that of theirs, that the suit was barred by limitation, and this whole of the sale consideration has not been fixed. But I am on first point. His right is not superior than that of the preemptor. The learned subordinate judge found that all the issues in favor of the defendant number 8 to 11 and dismissed the suit. On the main issue, he found that the defendants being obtaining a decree for preemption before the rival claimants had filed their suit had become vendees through court, and so the plaintiffs could not succeed unless they had a superior right. The plaintiff preferred an appeal to the additional district judge Farid Court against the said decree. The district judge held that the plaintiff and defendant number 8 to 11 had equal rights of preemption and were entitled to share the shell in respect of the 3/7 and 4/7 respectively on payment of the proportionate amount of the consideration. On the main question, he took the view that the defendant's suit was instituted for the reasons that by the date of filing of the suit, they had not deposited the purchase money in court. Both the parties filed second appeals against the decision of the district judge in High Court of Patiala, questioning the part of the decree which went against them. The High Court upheld the part of the decree of the learned district judge, holding that the plaintiffs were entitled to share in the suit property, but remanded the suit to the district judge to give finding on the following two questions. But I am not troubling your lordship regarding that, because so ultimately the conspectus of the suit, though initially dismissed, subsequently, my lord, it has been decreed in part. So both the parties filed second appeal, upheld. Now, my lord, in that matter went up to the Honorable Supreme Court. Now, if your lordship takes up paragraph 9. Has your lordship got it? May I place, my lord? The doctrine advanced by the learned judge, namely, the secondary right of preemption is simply a right of substitution in place of the original vendee, has been accepted and followed by the subsequent decision. The general law of preemption does not recognize any right to claim a share in the property sold when there are rival claimants. It is well established that the right of preemption is a right to acquire the whole of the property sold in preference to the other person. Next, my lord, paragraph 11, my lord, I am harping upon. The plaintiff is bound to show not only that his right is as good as the vendee, but that it is superior to that of the vendees. Decided cases have recognized that the superior right must subsist at the time of preemptor's exercising his right, and that right is lost if by that time another person with equal or superior right has been substituted in place of the original vendee. Courts have not looked upon the right with great favor, presumably for the reasons that it operates as a clog on the right of the owner to alienate his property. The vendor and vendee are therefore permitted to avoid accrual of right of preemption by all lawful means. Now, my lord, this has been clarified. What are the lawful? The vendee may defeat the right by selling the property to a rival preemptor with preferential or equal right. So, my lord, the vendees are being permitted even to transfer the property to defeat the claim of preemption to a person who have an equal preferential right than that of a preemptor. Now, this thing has further been clarified by the Honorable Supreme Court. To summarize, first, the right of preemption is not a right to the thing sold, but a right to the offer of a thing about to be sold. This right is called a primary or inherent right. Next, point number 2. The preemptor has a secondary right or a remedial right to follow the thing sold. Now, point number 3. It is also a right of substitution, but not a repurchase. That is, a preemptor takes the entire bargain and steps into the shoes of the original vendee. Number 4. It is a right to acquire the whole of the property sold and not a share of the property sold. Number 5.
Preference being the essence of the right, the plaintiff must have a superior right to that of the vendees or the person substituted in his place. 6. The right being a very weak right, it can be defeated by all legitimate methods, such as the vendee allowing the claimant of a superior or equal right being substituted in his place.
I am pausing for a moment. My lord is thinking, perhaps my lord has not expressed my lord's mind, but it's maybe passing through your lordship's mind that look, a person after getting notice of preemption, only to defeat the claim of the preemptor, have allowed something to be done by virtue of which what had happened, a person is being substituted in place of a preemptees or vendees, whatever I say, who has an equal right than that of the preemptor. Because today what has been done, the property goes back to whom? Again to another co-sharer who have an equal right in respect or than that of the preemptor in the present case. So if the Honorable Supreme Court is permitting that yes, even during preemption, by lawful methods, what is lawful according to me, my lord, had it been a case that there is a restraint order passed by the competent civil court, look, this has been filed, application has been filed, restraining you from creating any third party interest. So that cannot be said to be a lawful method, because subsequent stage of this judgment, the doctrine of lis pendens has also been considered. So today, if a person being a preemptee or a vendee is being permitted to substitute in his place by transferring even the property to any person than that of an equal right to a preemptor, then the preemption can be defeated, and this mode is permissible according to the Honorable Supreme Court. To defeat the preemption only because of the fact, taking into mind that this is Section 10 of the Transfer of Property Act, clog-on transfer, and it's a very weak right. So you are really restraining some person who is the owner of the property to transfer that property because you have a preferential right of offer. So initial thing is offer, then it goes quay to the property. So initial offer quay to the property. So taking into aid of this thing, the mode 6 which has been prescribed by the Honorable Supreme Court as has been summarized, and the initial portion of paragraph 11 permits the vendee to substitute in his place to someone who has an equal or even a higher right than that of a preemptor to defeat the claim of preemption. In my respectful submission, here also it's a case wherein whatsoever mode, but a legal mode is being applied for just to substitute the place of the vendee or the preemptees than that of a person who have an equal right to as of preemptor. And there are other possible ways to resist that. I say, once this has been disclosed, I shall show before your lordship, there are other evidence on record. This was put to a notice of the, even at the time of cross-examination, that these things happen. He said, I don't know, but this has been disclosed at the very initial stage in my written objection that this thing has already happened. But he took no steps and participated on trial. Issues are being
can be taken by him.
Your lordship knows, if according to him this is not a proper compromise, even if he is not a party to the compromise, he can always apply before the court saying whatsoever his claim is, that look, this compromise should not have whatsoever. These things which he has now in the appeal have
if both the parties, Mr. Mukherjee, have entered into the compromise, and the parties to the compromise all along we have this compromise is good. Can a third party
even is
Mr. Mukherjee, third party, yes, can challenge, but when both the parties to the compromise, they are saying this is a valid compromise, because Mr. Mukherjee, compromise is nothing but an agreement between the parties. So it's the intention.
Is lawful, he cannot stand in the way.
Yes, that is why those are cases, third parties can be challenged, those are in other cases.
Yes,
one of the parties is not challenging.
What is
one of the parties is not challenging. They are not there. Third party, yes, can very well challenge, or maybe claiming through someone, third party, he was not, can challenge. But here, in a case where both the parties are at item only compromise, whether
Like
third
Millard, it's a
party,
transfer. That happened, Millard, in the present case also. Millard, the Honorable Supreme Court gone, Millard, a step ahead. Millard, here also it's a case of compromise. But the mode 6, which has been explained by the Honorable Supreme Court, even the vendees are, Millard, permitted to transfer even the
no,
property.
that is
So-
a different
so
thing. But you are saying that they have not
if it is
taken
an
any step.
inter-virus transfer, there is no question of Millard throwing any challenge. If I am today has been left free, that I can
According
transfer
to
it.
you, this is permissible.
Yes,
To
if it is-
transfer,
yes. If it is permissible, Millard, there are something which called, Millard, lispendents have subsequently been explained, Millard, in this judgment also. Millard, may I place, Millard, those portion also? Millard, I have placed, Millard, paragraph 11. Now, Millard, kindly skip over paragraph 12 is, Millard, their provision has been quoted. It's not so relevant. Now, kindly takes up, Millard, paragraph 14. The provision do not, has your lordship got?
Yes, yes.
The provision do not in any way enable the preemptor to exercise his right without establishing his superior right over the vendee, the person substituted in his place, or prevent the vendor or vendee by legitimate means to defeat his right by getting substituted in place of the vendee, a preemptor with a superior right to or an equal right with that of the plaintiff. So, Millard, it's explicitly in so many languages, the Honorable Supreme Court made it clear that yes, until your right is being adjudicated, this substitution by the preemptees to a person either of a superior right than the plaintiff or than that of a equal right of the plaintiff can be made. Yes. Number paragraph 15. Nor can we accept the argument of the learned counsel for the appellants that section 28 precludes the court from giving a decree for preemption in case where the two suits were not joined together, but one of the suits was decreed separately. Section 28 enacts to convenient procedure, but it cannot affect the substantive right of the parties. We do not see that if the plaintiffs were entitled to a right of preemption, they should have lost it by the appellants obtaining a decree before the plaintiffs instituted the suit, unless it be held that the decree itself had the effect of substituting them in place of the original vendees. So if the decree substitutes, then it's permissible. We cannot therefore hold that the plaintiff's suit in any way barred under the provision of the Act. This leads us to the main question in this case, namely whether the appellants, having obtained a consent decree on 23rd January 1951 in their suit against the vendees and having paid the amount due under the decree and having taken delivery of possession and thus having got themselves substituted in place of the original vendees, can legitimately defeat the rights of the plaintiff, who by the reasons of the aforesaid substitution were only in a position of the preemptors of equal degree vis-a-vis the appellants and therefore ceases to have any superior right. Yes. The learned counsel, I am placing paragraph 16 because the points have been formulated. Kindly paragraph 16 first part. This leads us to the main question. I believe, your lordship has already read.
I've marked that. I've marked that as a corollary rule. Next paragraph, I've also marked that.
Then, I am not troubling your lordship. Your lordship has already read and marked, so there is no question of repeating. Your lordship kindly takes up now paragraph 17 onwards. Your lordship will get the doctrine of lispendents have been discussed.
Paragraph 18 it starts.
18 it starts. बोले क्या पूरा इंग्लिश Paragraph 19 for the time being, I am not troubling your lordship. That is with
This is
regard
on
to
me, sir.
limitation part, my lord, here on that question is not in. My lord, this
So up to paragraph 18 is the
paragraph 20 is, my lord, the another argument has been taken care of with regard to the compromise that has been, my lord, merely because the compromise has been ad idem, that does not, my lord, ultimately makes the right of preemption of the application itself nullified. But if that particular compromise decree gets a substitution being made, then what will be the effect that has been discussed?
compromise degree has to be a substitution because
yes,
if it has to be because if your intention is to defeat
a compromise, it always has to be
That
a
has to be.
substitution. I am allowing some person to be substituted in my place. Now, my lord, kindly takes up paragraph 22. Then, my lord, I am not troubling. After discussing all this, my lord, the effect of, my lord, lispendence, this judgment is therefore a clear authority for a position that the preemptor is not substituted in a place of the original vendee till conditions laid down in the decree are fulfilled. So that is not the other decision that has been considered.
Yes.
We cannot therefore agree with the learned counsel that the compromise decree itself perfected his client's right in derogation to that of the plaintiffs. But as we have held that the appellants complied with the conditions laid down in the compromise decree, they were substituted in place of the vendee before the present suit was disposed of. In the aforesaid view, the other question raised by the appellants do not raise for consideration. As a result, the appeal is allowed and the suit dismissed with cost. So, my lord, here there was a case where there was a rider. Since that condition that needs to be fulfilled, otherwise the substitution cannot take place. Here, my lord, in my respectful submission,
that is the conditions in the compromise degree has to be that has to be otherwise compromise degree
there is no
there is no meaning. Yes.
There is no meaning.
Does not take effect.
My lord, if I can,
Or the substitution does not take effect if the conditions
if
are not
ultimately, my
satisfied.
lord, I can demonstrate before your lordship this method, which has been
permissible.
If it is permissible, my lord, if it is not beyond the law, if it is not to be said a malafide, my lord, steps in a preemption proceeding.
My substance is that substitution during the pendency of the suit is permissible. So if it is permissible by whatever mode, sale or
my lord, paragraph 11, my lord, has been, my lord, categorically Honorable Supreme Court has given, my lord, even the examples. I can fit in example number 6. So if, my lord, otherwise, my lord, it's permissible, then in my respectful submission, when my compromise decree, which has not been challenged or whatsoever steps they could have taken, my lord, I am not there. But till today, there is no rider. Both the parties ultimately ad idem, instrument goes, my place is being substituted by a person in the present case who is equal than that of a preemptor.
yes.
Another judgment without wasting your lordship time, just to this is the 2005 volume 2 CHN, page 139.
That is
Paragraph 15.
1.5.
Lord, 139, yes, paragraph 15.
Yes. This is for what proposition?
Lord, it is only this to show that whatever he's saying, Lord, that he's right on the day, Lord, that your lordship, that's Lord, perhaps disturbing your lordship mind, on the day when, Lord, this application has been filed, he may have a sole, Lord, preferential right at that juncture. But the law suggests that he has to maintain that till, yes, that is well settled. Lord, paragraph 15.
Can you give me a photocopy of
Yes,
that?
So we will not be photocopies. But I'm sorry, but I have just opened the page where the paragraph 15 is there. Volume 2, CHN 139. Here, Milord, also within this judgment, this Honorable Court, Milord, has laid down that whenever the transfer took place, again and again the right to filing application for preemption accrues. It's not only in respect of the earlier I have not given, so subsequent also I can choose. Where the Honorable Supreme Court has made a departure.
Transfer gives the right.
Yes, accrues the right.
Accrues the right. Give a photocopy of
I shall give that photocopy.
Yes.
But in this backdrop, not in my respectful submission, I have already shown before your lordship, my suit is of not that a declaration, a decree for declaration that the instrument is void, not an out and out sale. Even the learned appellate court is not correct in saying that it is to be valued, my lord, according to the subject matter. My lord, executability of the deed has never been challenged by me. I say it's a loan in substance. It's not an out and out sale. The person comes and compromise it. So there is no question of this kind of suit, which according to me is not a executability of the deed is being challenged by the executor. The instrument, the caption of the instrument, I say, though it has been captioned in such a way, but it is not intended to be executed in such a way. So executability has not challenged. The substance of the deed is being challenged, accepted by the other side.
Show me the compromise.
Yes, my lord,
terms of the compromise once.
Once, my lord, your lordship looks at the compromise terms.
What is the page compromise?
Yes, my lord, Solenama starts with page 34 of my lord's brief.
That is the compromise petition.
Compromise petition, my lord, Shortaboli start, my lord, the terms of compromise starts at page 35. My lord was on the last date, was on, my lord, the point number 2 itself. Substance of my suit was that it's not a out and out sale. And he accepted also it's not acted upon.
So the compromise petition states, in effect, states that the document, impugned document deed, was not a sale deed, but it was a loan in substance. That's the.
And it was not acted upon. Lord, all possible means have been there to nullify the instrument. I must say. That's why, my lord, I try to find out something that ultimately which, my lord, permits the conscience of the court that whether this can be. My lord, if the Supreme Court is saying you can transfer. So it is something voluntary act of the person, not even dependent on a court's order. So if I can transfer lawfully, obviously, my lord, I say, my lord, with a rider lawfully, because nowadays I find, my lord, with greatest of responsibility that even the preemptor on the very first day has to apply for an injunction. Even, my lord, I was not aware of this Honorable Supreme Court judgment prior to this matter. Lord, but if it is a authorized mode, then what will be the necessity for an applicant, my lord, to apply for preemption? Because it can be undone at any point of time. So if it's a lawful method, and even if a transfer is being permitted, so it's an unfettered right given to the preemptees. It's not a something which has been done only to defeat of preemption. That could have been the greatest, not best case, that yes, once you being notified that yes, a preemption application is being found, so you may transfer. So that's why this is a possible mode by virtue of which I can frustrate the claim. The Honorable Supreme Court is saying, yes, you can do that. You can do that, but provided it has to be a lawful method. Now, lawful method has been not given example 1 to 6. Possible example, I cannot say it's a restrictive illustration, but still, by 6 illustration, it has been stated, one of the mode is that even I can permit transfer also. That's why substitution with 2 of the, I can substitute to someone who has a greater right than that of a plaintiff or an equal right. If it's an equal right in the present case, it's become a equal right. Take it, my lord, not a decree. Take it, it's a transfer. Whatsoever sense, not in a strict sense, I'm saying, if it is permissible, I can gift it. If that be so, whether this can be said to be a mala fide act in a application for preemption. If it is not, in my respect to submission, then, the entire exercise, because the property has gone back to the person, who has transferred it. So it's not that, that subsequently my right goes. In any event, my right goes. Lawfully, my right goes. So in any event, if something thereafter is to be done, then the right
suspicious,
actually,
Mr. Mukherjee.
my lord,
That is suspicious that your right has gone. Because with the force which you are arguing, it shows you have some right.
No, my lord, the force, my lord, your lordship, not that.
Because Mr. Mukherjee, one thing, basic thing, a person, a person, because now, as it goes, from the compromise decree, you have nothing to lose.
They are also, kindly consider the Honorable Supreme Court also. All the parties were there.
No.
Both
maybe,
of them has filed the appeal.
Maybe, but
right of appeal, even your lordship is saying, what
in any transfer, Mr. Mukherjee, in any transfer, I'm not on this. Please think of any other, I'm not on this transfer. Any transfer during the pendency of a suit, let us not think of this. What's the usual? What is the logic? Because the person who acquires subsequent interest during the pendency of a suit is that person who really contests.
Sometimes your lordship has experience.
The law is
even the client for whom the the arguments are being made, your lordship knows, this can be under order in the preemption application.
There are two things. One is
the transferor is not a necessary party.
That now, yes, you are very correct. Transferor is not a necessary party, but the transferor now has become the owner, because initially because why the transferor is not a necessary party in a preemption, because now it has gone to the
then I'm so grateful to your lordship. Then once my written objection is there on board, so what should have the possible steps?
Please allow me to complete. Once it has come to the preemptee, now the transferor do not have any right. He is not a necessary party. Now, if
again retransfer,
yes, now transferor is a necessary party, and transferor is aware of this fact. So transferor is keeping silent, but the preemptee who has lost an interest,
the transferor is keeping in silence. Mr. Transferor has not been notified. What the preemptor? It is the duty of the preemptor.
Let us think of a hypothetical situation. What you will lose if you do not contest this proceeding?
I say the instant proceeding after my written objection and not being added by on the behest of the preemptor, the original vendor, the application itself is not maintainable.
Which application?
The present application.
No. I follow that. But
present application is not the revisional application.
My question to you is a different thing altogether. What you will lose if you do not contest this proceeding? Why are we interested in prosecuting this litigation?
I am interested. I have been arrayed. I was, in the initial instrument, I was one of the beneficiary of that. So
you was at point of time.
That's why
now, after this transfer, were you really required to contest? Because a person really transferring will not contest. Look, whatever it might be, I will not contest. Maybe you get a decree, what you will execute against. There's nothing against.
But I say it's a good citizen.
Practical situation.
He's a good citizen, Milord. He ultimately have executed something and he is fighting. Milord, it's not.
I'm not saying that, but that's their real.
I cannot say much beyond that. I cannot say much beyond that. Whatever you're falling from your lordship's mind, that is perfect. That is. But after divesting my interest, after the substitution being made, now the vendor of mine has been stepped into the
for substitution is only because of that.
Yes, but
why? Because if the subsequent
yes, I bow down.
Does not come in.
I bow down. That's why, Milord,
interested
that
now
perhaps
continue.
That perhaps, Milord, your lordship's queries answer, which I could not able to give, Milord, at the very first instance, that what could they have do? But they could have, my lord, in this application itself, after this fact has brought to the notice to them, my lord, in the written
To add
objection,
them.
to add them.
That will be my, the question which you are putting to yourself. I will give that in the answer in the order.
In the order?
The question which
Your
you have
lordship
put
has,
to yourself.
then your lordship has, so there is
No.
this much of my submission. But I cannot.
This, I'm
Yes,
saying,
yes,
so
yes.
this is the question which you are saying, what will be there, that will be the answer.
But no, that is the carriage of proceeding is with them.
Whether
That
they are
is with them.
required, whether they it's required to
That,
be
my lord, they
implemented
have,
or not.
that they have not even, my lord, tried to brought in, my lord, these vendors of mine to the record of this present proceeding, but they have participated on trial. There are recording, my lord, in the
Who have
trial court.
participated in trial.
The preemptors,
They have to, because
they,
they,
my lord,
their
once
suit,
their application, they have been, my lord, notified that, look, your
So I follow your
Yes.
argument that since you have notified them,
But
you have
some
told-
effort, Milord, some effort, a person has approached the court. He has not obtained any order of injunction. If these things are permitted, but if these things are required to be undone, some effort has to be there. But otherwise, Milord,
they might not be knowing.
Yes.
Because this, no. I'm not saying about this transfer.
My lord.
This decision. So you are making the submission on the basis of this decision. This was not relied upon. So they may not be also knowing. They may not also be advised on this. What is the subsequent
No,
advice that
that's
they
why
will?
that's
Whether
why I said-
after this proceedings, they are required to be required to implement that, they will take decision after this court passes an order.
because today we are on order of remand.
So now the
And
limited
Milord, your
scope
lordship, also Milord, bears your lordship's mind, Milord, that particular issue with regard to this maintainability has been decided by the appellate court.
Yes.
It's
there
not
are
an
two ways.
open remand with regard to
There are
that
two-
issue.
There are two ways. So one thing which I put to you was that
Because
if I-
other issues has not been thrashed out, not before the trial court,
that
not
is
before
why
the
I-
appellate court.
That was why I gave you that option, that the appellate court has not decided the other issues, but the evidence is already complete.
My lord.
So appellate court decided one issue in one way. So other issues, if the appellate court decides,
There, my lord,
there are two ways.
My
There
lord,
are maybe two things. One, the appellate court on facts may say yes,
My lord.
though it is maintainable, but yes, he is not entitled
Entitled
to.
because I have
on
other
merits.
points also, which are
On-
pending before the larger
That
bench.
is why on merits, he is not entitled to an order of preemption. Even though the preemption application is maintainable, but he may not succeed ultimately. That's one way. Then ultimate thing, whatever is that, it comes before the court for a fresh challenge. Other thing is that if the remand is held, now it's go to the
Trial
go
court.
to the trial
Trial
court.
Because, my lord, I also say, because if it is otherwise decided by the appellate court, I was losing a four-out. Because other issues has not been decided by the trial judge. Trial judge disposed of the, or rejected the application for preemption only on that issue. Because it's not maintainable, instrument goes. The appellate court decide that issue. There, my lord, I am joining an issue because once that issue has been decided, so compromise gone. That's why I am before your lordship. If the compromise gone, then my title again revives. So that's why I am before your lordship. Today it is not that I don't have anything. Once that issue, because the appellate court, I am not disturbing your lordship again and again, the appellate court said the compromise is itself bad. And thereafter said rest of the issue to be decided by the appellate court, by the trial court. So he could have said that these points with regard to jurisdiction, which has been urged for the first time by the appellate court, let that issue also be decided. It's not an open remand. That all these issues, let it be decided afresh. I could not have come here in that event. But he closed that issue. Said, no, this I am deciding, so
No,
this compromise is gone.
Mr. Mukherjee, that has to be done because the trial court decided that issue.
Yes.
Appeal court has to decide that issue. There was no option open to the appellate court.
Only the issue.
Either he has to affirm or reverse that. That's exactly what the appellate court has done.
That's why I say, even on that issue, if your lordship is with me, then also the remand order, I am okay with it.
After setting aside that, Mr. Mukherjee,
because in either way, your lordship has to decide only on the point of jurisdiction whether this
even if
compromise will go or
even
not.
if it is set aside, why it should be remanded to the
No,
trial?
my lord, I say if it is decided that whether the compromise itself is bad or not, because compromise has been held to be bad by the appellate court only once court. That is
No, according
jurisdictional
to you, compromise is valid in view of this judgment.
Not only this judgment, but the appellate court has not gone into my conduct. The appellate court say that court do not have jurisdiction.
No, even you succeed in this civil division application and it is held, yes, compromise is valid, then there's no issues going into that.
Left to be decided.
There's no issues going into that. If other way around, the issue is
what I just thinking, my lord, that this point of jurisdiction has not been either urged by any of the parties before the first court, before the trial court. The appellate court can say that, look, this point of jurisdiction is also an issue for which this order I am setting aside. You consider that issue along with the jurisdiction point and decide afresh.
Mr. Mukherjee, here it is not a case that the trial court did not.
No, trial court has not gone into the jurisdiction issue because this point has not placed.
What jurisdiction?
This
jurisdiction of the court. No. May not have. Mr. Mukherjee, trial court has decided that the compromise is good and he does not have any.
Because other side has not made any challenge, so it's
because he does not have any right to proceed with that. So the trial court dismissed the preemption application, holding that the compromise is valid. So when the compromise is valid, it has to be that the jurisdiction of the court was there. Now the appellate court has went on the jurisdiction as well as other parts, conduct.
Because below it's not always below a section 3. It's not about the limitation or something. The suo motu, the jurisdiction with regard to the valuation. Milord, the court suo motu take it by the appellate court. That look,
it goes to the root of. It goes to the root
to have been.
Mr. Mukherjee, rightly or wrongly, whether the court, whether the appellate court went was right or wrong in holding, that's different thing altogether.
Yes.
But the question of jurisdiction, that goes to the root of the matter. If prima facie, let us suppose that a suit for specific performance of contract valued at 3 lakhs is being filed before the civil judge.
Yes, Lord, I am bowed down. If it is valued 3 lakhs and filed before us,
that is also.
But here, Milord, he is saying
no. That is
have been valued at.
That is a. I'm coming to that.
Yes.
Now the suit for specific performance valued at rupees 3 lakhs filed in the civil judge junior division, and the court.
Ex specie if it is
court decrees that suit.
Yes, ex specie if it is.
So appellate court can say no without jurisdiction.
Always. I bow down.
Second is what you are saying. Let us assume a case where cancellation has to be paid for, but not paid for.
But then I am joining. Yes. But then this will be an issue which they ought to have brought to the notice of the same court by filing an application that which is permissible. That look, he is really reopening a decree, a compromise decree, but a decree which has attained finality. None of them challenge. In a collateral proceeding, there are certain boundings. In a collateral proceeding, without throwing a challenge with regard to the caption of the suit, how it has to be valued, when it is permissible. A party being a third party before a same court can say, look, this compromise is not binding because of this reason. 22 Supreme Court is categorical. Peak system has been considered. A party, a non-party, whether the appellate court or the same court. If that be so, then it's something which needs to be gone into in that proceeding, not done by them. They were a fence sitter, they allowed these things to be happen. Now, whether this point which has not been taken by the trial judge at any point of time, no pleading, nothing into that sort, as if I could have understood that their preemption application is being amended, taking this plea. The appellate court take up suo motu in a close suit which has been decreed, not touched, in a collateral proceeding, saying that conspectus of suit is such, you ought to have been valued the suit in such a nature, and in that event the court will allow pecuniary jurisdiction, and for which the compromise is not valid. But whether this stretching of thing can be permissible, subject to rider, your lordship consider that also. But in my respectful submission, even if that angle is being thought for, it's not a case where the court lacks pecuniary jurisdiction.
No, your case is that cancellation ought not to have been paid for in a case of this nature.
This nature.
If the
Because my-
cancellation is not required to be paid for, then it's with jurisdiction.
Executant is not
Because-
saying that I have not executed. Execution is not being challenged. He said the gamut of the instrument is not of an out and out sale. Other side comes and say,
It
yes,
is
I
in a case of cancellation of the instrument.
This is my respectful submission. And Milord, if this be so, Milord, in my respectful submission, Milord, today also, Milord, once the compromise gone by the appellate court by a stroke of pen on that score, Milord, my right also accrues, Milord, to maintain the present civil divisional application, even in absence of Milord my vendor, who Milord has substituted in my place, but after the appellate court judgment, again, Milord, this has been revived. This,
Yes, madam, you have taken notes. Tomorrow,
gives one day, Milord, more to Mr. Roy. Milord, I will narrate these things to him. But this request, Milord, otherwise Mr. Roy will be surprised. I will. এটা একটা জেরক্স করে দিয়ে দিন। তো তাই তো নিয়ম লিড করতে হয় না
ফাঁকা দিলেন যে
ঠিক
4 p.m. How much time Mr. Roy will take? Not more than 15-20 minutes.
He is an authority, Milord, under preemption. He will.
তাহলে বলছেন না সেটি seventh.
আমাদের আলিপুর কত?
7th. Yes. No. What you are saying, Mr. Roy?
Roy is an authority, Milord, in preemption matter. Milord, he will not take. I will have to just give the clue that yes, this I have argued.
No, I could not hear. Please come here.
আমি লোয়ার কোর্টে ছিলাম। I am representing in lawyer on behalf of the respondent. Yeah.
Oh, you are conducting the case in the appellate court or the trial court? Both.
Both.
Yes. Thank you. So you must have heard Mr. Mukherjee's submission. You have taken notes also. Mr. Mukherjee, learned advocate,
Last chance only the suit is being posted as a last chance.
When?
Not last Monday was the date fixed. Next date has not been posted. The learned judge is quite annoyed, my lord, that after remand we are not proceeding the matter. So
So it's notice fixed for what?
for argument.
Because evidence are
Yes,
complete.
that's
They
there lies the
filed
difference.
Time petition
For
easily
yeah,
allowed. All time petition will be easily allowed. Fair.
it's not allowed. That's why I shown before your lordship keeps at last chance.
Now he has made his argument. Now the ball is in your court.
Lord, for limited period, your lordship protect me. It's not that, Lord.
What is the